filed by the respondent number 5, that may kindly be called for.
Hmm?
In item number 3, Lordship, an affidavit has been filed on behalf of the respondent number 5. That may be called for, Lordship.
Hmm.
In the last occasion, my lord, they were supposed to file an affidavit, my lord. But no affidavit is filed.
Lordship, we have received the instruction. We'd like to file an affidavit, but the issue is here that the cancellation for the tender is because there was a missing clause, the Lordship. If I may place this instruction for once, Your Lord.
Mr. Bulwer, the matter has come up for the first time before this court. It's in the motion stage. Though coordinate benches have passed certain orders from time to time. But the question is, what is your case?
Yes, my lord. Actually, what happened, my lord, the tender was called for construction of the building, my lord, of the at Madhuli by the forest officer, divisional forest officer Madhuli, my lord. And tender was, tenderer has participated in the tender, and my lord, the petitioner was found L1, my lord. And as per the tender, my lord, there is a clause. My lord, kindly turn to page 43, my lord.
Yes.
43, 37.1 clause. That is in middle, my lord. The employer reserves the right to accept or reject any bid and to cancel annul the bidding process and reject all bids at any time prior to contract award without thereby incurring any liability to the bidders, for which the employer shall keep record of clear and logical reason properly, and for any such action recall the bidding process. In case of cancellation and all bids submitted and specifically bid security shall be promptly returned to the bidders. My lord, there is clearly stated that there must be some logical reason, my lord, and they can.
Then,
And my lord, while my lord, they have rejected my entire tender process, my lord, kindly turn to page 61, my lord. This is the cancellation corrigendum, my lord. At page 61, annexure 8, lordship. Lordship.
yes.
At page 61, this is the cancellation corrigendum. This is to inform all the concerned that the following tenders, all by the office of the undersigned, IOO number so and so, dated so and so, are cancelled as directed by the Conservator of Forest, Eastern Assam Circle, Jorhat.
What was the estimated value of the contract?
The estimated value is 46 lakhs 98,000.
40?
6 lakhs 98,000.
And you quoted 30?
8 lakhs 51,999.
30?
38 lakhs 51,999. In this
And what is this percentage? Minus
minus 16.75
16.75.
below.
Okay. Their only ground is the variable, the viability range was not mentioned in the
Exactly,
tender.
that was not mentioned in tender, your lordship.
Now, do you have anything mentioned out there in your, what you call, tender, not any general terms and conditions which states about that there should be a viability range of plus minus 10%?
In general terms and conditions, there is no mention about it, your lordship.
Huh?
There is no mention about it, general terms and conditions in a tender.
No. Normally, do you have, like most of the departments have that? Do you have similar to something to the effect? Like a PWD has
PWD
a
has-
viability
yes, your
range
lordship.
as per whatever there is.
That is, my lord, the order by the governor in respect of the rules, my lord.
So they will have to give an additional
Yes.
security.
Yes, sir.
In regard to that, your lordship, whether we have in other tenders, whether we have this clause or that we have to verify with the authorities, whether
Huh?
we have to ask for the instruction for the authorities.
No,
whether
no,
they
I
have-
don't understand. When the notice, you were asked to obtain instructions in 16/6/2025.
Yes, your lord, that's the instruction.
Does
we
it
received.
take such a long time?
Yes, we have received that instruction, but that query was not pointed toward us, whether we have in other tenders, whether in the terms and conditions, whether this clause was inserted or not. That query was not put. The retender call only for the process that since that plus minus criteria was not there, that's why they were asked for retender. And it's not that we have given the work to the petitioner, lordship. No work order has been issued.
Now, what do you say about this notification?
That this notification already forwarded to the authorities regarding seeking the clarification in this regard, your lordship. But that institution was say awaiting, your lordship. But now the issue is that since the retender was called for, your lordship, just because it's missing clause. This-
Understood. You don't have it, but how do you take care of this? Because this is as per the Assam Procurement Act.
Yes, your lordship.
Now, this is an act and by which it regulates all the tender processes.
Yes, your lord, true.
So therefore, you are bound by this.
We are bound by this. Since
So
they
if this is, you are bound by this, then why you are not adopting a similar approach which is given in 1.1? Why this is not being done?
that's why the retender was called for, because this was not being done, your lordship. That's it.
No. You don't need to call for a retender. You have to have discussion with the lowest bidder as to how you are in a position to do it. Now, if you are satisfied with that, okay, with 36 or 38 lakhs, he is in a position to do it very well. But you will put with him that you have to give an additional security of 250%. You don't cancel a tender. This notification is just for the purpose of transparency.
Yes, sir.
Because tomorrow, when the authority concerned does not find his bidder having quoted the lowest price, then the tendering authority will cancel it. 37.1 is there. You have a power, but the power has to be exercised in a fair manner.
Fair.
Merely because when you have a notification of this asset, then you have to perform this exercise. Now, if you are not satisfied with because he has given the details, how he is going to do the construction, because you have to give everything. So if you are not satisfied with that, then you have to go ahead with as per this, because this is the notification which is holding the field.
Yes, sir, true.
We have to interfere with this type of exercise of retender. We do one thing, we issue notice, because without issuing notice to cancel it doesn't proper. But I'll mention about this
Very
notification
well.
and take a decision on this and then come back
Very
in a
well.
week's time. Because after all, if there is a delay in construction, it will go to, it will have a impact.
Exactly.
Now, when was this done? You are ready to enhance your bid validity.
Definitely. Definitely.
Issue notice, making it returnable on August 6th, 2025. Post. Mr. R. Gogoi accepts notice on behalf of the respondent numbers 1, 2, 3, and
respond.
4. Extra copies of the writ petition be served upon him during the course of the day. Post. The petitioner herein is aggrieved by the action on the part of the respondent authorities, and more particularly, the respondent number 4, whereby the tender insofar as tender bearing tender ID number 2025 underscore PCCF dash underscore 43093 underscore 1 for the purpose of construction of range officer cum range office quarter Goramur Majuli was cancelled. By the cancellation corrigendum dated 19/5/2025. The learned counsel appearing on behalf of the petitioner has submitted that in pursuance to the notice inviting tender bearing number OO NO 02 dated 18/1/2025, the petitioner along with 5 other tenderers, 5 others,
Four others. Total five.
5 others. 1, 2, 3.
Five others.
5 other tenderers had submitted the bids. The petitioner was technically responsive. Further to that, in the financial bid, the petitioner was the lowest bidder. The learned counsel appearing on behalf of the petitioner further drew the attention of the court to the fact that these tenders come within the ambit of Assam Public Procurement Act
17.
2017, read with the Assam Public Procurement Rules 2020. And in that regard, had placed before this court a notification dated 30/7/2024, wherein it has been duly mentioned as to what the tender inviting authority is required to do if the bid so submitted, the financial bid so submitted is below 10%. The learned counsel appearing on behalf of the petitioner further submitted that no steps in that regard was taken, and in order to favor some blue-eyed persons of the respondent authorities, the entire tender was cancelled only for the cancelled. The notification so placed before this court during the course of the hearing is kept on record and marked with the letter X. The respondent authorities, Mr. R. Gogoi, the learned counsel appearing on behalf of the respondent authority, submits that he would obtain necessary instructions and file an affidavit in that regard on or before the next date. Taking into account the above, this court further continues the interim order which was passed
23/6/2025.
On 23/6/2025 till the next date.
Eligible.
And what is wrong? The forest department doesn't have money or doesn't have a good printer. You can look what it is.
This is not readable, man. This is not readable. Very light.
All right, sir.
Mr. Gogoi, I will interfere on the next date if you don't come up. I think you need to do this exercise.
Here the petitioner applied for the electricity connection. Here the petitioner applied for the electricity connection
Ah,
and completed all the formalities, but till date they could not supply the electricity connection, Lordship. And we have deposited all the required amounts. That is
Malad, may I
annexed.
kindly see the last order, Malad? I don't know why he's making the same submission, Malad. The honorable court had directed him to obtain instruction from his client.
petitioner's case is that petitioner has approached the respond number 3 for supply of electricity connection to the daffodil and that they also deposited required repairs on collected here. It shows that there is already an electric connection in DR apartment in the name of Sunil Chandra Boisho, who was the original owner. Further, electricity is being provided to the said elector which bears the council for the AR further submit that along with the petitioner's application for grant of electricity connection having capacity of demand to a 11 kV and submit 2 letters. Wherein saying the petitioner would provide the right of way for construction of demand line and the same would be done at the cost of it. The construction of the could not be executed due to local persons objecting any. Yes, what is your case?
Chief, kindly go through these two documents. They are relying on these two.
Understood. First, tell me what is your case?
They applied for the electricity connection. They could not supply till
Electricity connection where?
to my premises, daffodil apartments, Lordship.
You want for the apartment or only for the flat?
Entire apartment, Lordship.
So the entire apartment, you need a connection.
Yeah.
Okay, now what has happened?
11,000 volt Lordship. And they are relying on that electricity, that is temporary electricity connection, Lordship, and was taken for the only for construction. That is 74 kilowatt. Now we are applying for the 1100 kilowatt, 11,000 kilowatt, Lordship, but they could not supply till date. When I completed all the formalities and deposit the required amount, that is 12 lakh 1,400 something. Lordship.
So you will require a transformer.
Lordship,
You have got a transformer.
no.
Why?
They could not provide till date.
Malad, this is slightly confusing. What the issue is, Malad? On the last occasion, I had passed on a set of instructions, Malad. They are part of the record. Based on those instructions itself, Malad, the order was issued, passed, Malad, by the earlier court on the last occasion, Malad.
There is nothing on record.
Malad, I'll give my copy then.
They are relying on these two undertakings. That undertaking was given only for my premises. How can I give undertaking
No.
to provide space in
These were the
particular Lordship?
If I may just submit, Malad. These were the instructions, Malad, I received from the SDE, Malad. What has happened is, Malad, on page 6.
Ah, that is what I am telling you. You require a transformer.
Yes,
Lordship,
So the transformer, who is to buy? You are to buy.
they are
Lordship, for that I deposited the amount that
You have to buy the transformer somehow. Have you taken the estimate from them? Have they provided you the estimate? You see, when you apply for electrical connection, you must be asking for a 250. How much load are you asking for?
11,000 volt. 11,000 volt, Lordship.
Mr. Council, how much load you are asking for?
11 kV.
11 kV?
11,000 volt, Lordship.
Okay, the flat is, the apartment, how many floors are there?
Only 7 apartments. Only 7 apartments, Lordship.
So 7 apartments are there. So 7 apartments which will be there, anything above 20 in an apartment, there will be requirement of a transformer, 20 or 30 required. So obviously it will go beyond that. So you may have to take a 63 kV transformer or 128 kV, 64, 64, na?
64.
64 or 128 or 256. So have you taken that transformer? Have you taken from them that what is the estimate? Have they given you any estimate for that? Because without the transformer, first what is required? You have to have a transformer, purchase it, then you have to place where you have to mount it. Then only they will provide you the electricity. Where is it?
Page 6A, my lord. This is
Huh?
Page 6A of that instructions, my lord. Is an un-
6?
6A.
They are relying on that.
6A is an undertaking furnished by them, saying that they would provide the transformer.
Yeah, you are asking, you say that, yeah, see, that the 11 by 1 by 100 kVA transformer along with the requisite materials for construction of the so-and-so of the premises of the understood DR so-and-so will be supplied by me at my cost as per the specification of your estimate. That is for your consideration area. This is being given by you. So therefore, either you have to obtain the transformer, put it in the mount where it has to be mounted out. You can't have it inside your home. It has to be outside. So you have to have a place, construct. Then only you can take and give it. Or ask them to kindly provide the transformer, which obviously they will do it at a more premium price, which the APGCL has the habit of doing. So either of it, I can't help you with this.
If only 1 week, then I will take instruction from my client.
Okay. Buy 12 and withdraw and go. Do the needful. This is how you cannot get a connection unless you have the transformer.
Yes, ma'am. And these facts, my lord, have not been brought before the honorable court, my lord. These facts, my lord, as regards the undertaking, have not been placed before this court by them.
I understand everything. You must have asked some contractor for an estimate. They must have given an estimate of a huge amount on the transformer. So you must have said that, look here, I will provide the transformer for myself and the area. So unless you have that, where is going to be the connection? 12 o'clock, withdraw with liberty
No,
to
1 week
proceed.
notice.
And you help him out what it is required.
Yes.
You see, after all, having a temporary connection is not in the interest of APDCL also. He wants a transformer, he has to purchase it.
But there is also another issue as regards erection of the electric poles and connection of the line leading up to the transformer. They've also said, my lord, that those actions have not been undertaken by the APDCL. my lord. The issue is with regard to the right of way or the way leave permission. That again falls on the part of the applicant itself, and they'll have to provide it. So that
So
page
far,
6.
our premises is concerned, I can
Not
provide.
only that, you have to also provide the poles.
No,
That-
only
that
the
is
way
in
leave
the
permission.
public
Huh?
road.
Me here. The way leave permission or the right of way is in their domain. They'll have to provide it.
You are
And
not
the
getting
local
it.
In public road, how can I provide space to install
page
pole lot
6,
shape?
my lords, of my instructions. Kindly rest.
And they relying on that. In premises, we have provided space to install transformer, but how can we give undertaking to provide space in public road? That may be considered. And I'm relying.
Page
if
6
lordship
of my
permits me,
instructions, my lords.
If
That they-
lordship permits, I'm relying on judgment of apex court. Similar identical things what happened, and apex court directed to respondent to provide electricity connection because neighborhood raised objection for installing pool and line was taken to their premises.
No, what is your problem in providing that thing? The right of way, they cannot, means if it goes
Lordship permits.
inside somebody's premises, the private premises, it's okay. But that obviously you cannot.
Because on numerous occasions, we've attempted to provide the connection. my lord. There are certain local people, my lord, residents of that very same area who have objected and have not allowed our contractor to carry out the work. my lord. Now, again, that falls within the domain. my lord. In fact, the electricity supply code also says that the way leave permission has to be provided by the applicant.
You can take
4.3.2.
help of police lordship by virtue of section 67 of electricity act. And this is the judgment I'm relying. similar thing was happened, identical. And honorable apex court directed the respondent to provide electricity connection.
Yes. What do you say about this judgment?
I'm not aware of this.
Have
The
a look.
One. Similar identical thing was happened. Neighborhood raised objection.
4 point.
4.3.2, my lord, at page 35.
Hey, electricity account. Electricity. account. This law cannot, by this, because electricity is the essential commodity, you
Yes, sir.
cannot.
I'm completely aware of that. But the issue is when the local authority, then a direction may be issued, my lord. I have no objection to that effect.
No, taking into
Now,
account,
but the fact remains, my lord, he's only become wiser after the fact. All these things were never brought before the honorable court in that they are not even mentioned in the writ petition. When I produce the instruction, then he says all this.
see, all the lawyers may not know many things. Huh? You are accustomed to many things, isn't it? So we do one thing, we dispose it of now. As regards transformer, where it is to be mounted and evaluating, he is going to do it.
He's going to provide the
He'll
transfer.
do it. And as regards the right of way, we follow the judgment of the Supreme Court out here, along with 67, section 67. And then you take it out.
Then liberty may be granted to approach the local police authority
Ah.
for all the assistance.
Yes,
Any assistance.
67, the power is- Now, this line has to go within the premises of some private
No,
persons.
it's a public road.
That, my lord, I do not know.
It's a
That instruction I
proper,
do not.
I have instruction, lordship. It's a public road.
Chalo, we do one thing, we'll have it, today is Tuesday, na? Let's have it tomorrow. You have that instruction. Is it possible?
Yes.
Just find it out whether it has to go. And you give me a proper map
Yes, I
diagram
can get that
tomorrow.
instruction by 12 also. I can call them and get. that.
Well,
Yes.
you let him give me as a proper map diagram
Lordship.
tomorrow.
I'll try.
Yes,
Then we can further say it in our order
Then lordship, so for tomorrow,
tomorrow.
then it
Yes.
will convenient for me to take instruction.
Huh?
It will convenient for to take instruction.
You take your instruction and
Lordship.
give a proper map diagram
Lordship.
by which the line has to go. And where is your, does your flat or the apartment is on beside the road? Or is it inside somebody where there is no frontage for them to provide the electricity?
Lordship.
If it is over the streets, then they don't have any problem. They have the power. But a question arises if it goes inside somebody's house. If your flat is inside a place and you don't have a frontage, and then it has to pass through, then they have those people who are causing the disturbance, they have a right of compensation.
I'll take instruction.
Take that instruction. List the matter tomorrow at 10:30. Ikaw ready? Huh? Ito ready. Ito ready. You give it to him. And this book. Aman.
Actually, your lordship, in this series matter, Mr. Dinathi Deveri, today he has filed affidavit lordship. Lordship may take up this matter after some time. He is in Lexington Court number 1 lordship right now. After some time, lordship.
Let's have it at 2 o'clock. 2 o'clock.
Lordship.
Mr. Yeah, Mr. Kolita also here.
Kolita.
Mr. Kolita, I was thinking what order to proposing to pass is they are filing some affidavit that will look into it. That thereby directing whenever a delayed application is filed, the Motor Accidents Claims Tribunal will keep the application in abeyance after registering it in abeyance and thereby call for a DAR. The final one is the DAR. DAR as well as all the other formalities which is required. And after getting the DAR, that DAR along with the claim application together will proceed for the purpose of disposal. Because as per the mandate of the law, the DAR has to be filed. And the DAR is to be treated as a claim proceedings. So along with that, the claim proceedings will proceed. I think this is the best way out by which you are not touching on 166(3). You are not touching on, but you are still keeping their right alive. When the Motor Accidents Claims Tribunal asks for that, DAR and the charge sheet. And then it would be the duty of the Motor Accidents Claims Tribunal to take it up with the concerned officer in charge or the investigating officer when it is filed, how it is to be filed. I think this is the best way. Now, only one problem which I feel. If they file it in some other place.
Yes, sir.
Just for example, the accident happens in Nagaon and they file it in Guwahati. Then how do you tackle this situation?
My lord, there is a notification of our High Court, my
So
lord.
that I know.
Yes.
That High Court's notification is after that Gohar Muhammad's judgment. In wherein it says that whenever, because Gohar Muhammad categorically says,
Yes.
I think in paragraph 53, I suppose, wherein it says that the moment there is a DAR and the claim petition file, the DAR moves to the claim proceedings. That I
That
understand.
has to be called for.
Now, the question is, if the claim proceeding is filed in Guwahati and it is delayed, now the Motor Accidents Claim Tribunal will ask whom and the accident happens in Nagaon. Then what do you do?
So far, my understanding goes, my lord, the concerned tribunal would be asked to provide the TAR report.
Understood?
Yes.
So, therefore, the question is the Motor Accidents Claims Tribunal in Guwahati, because the DAR had not been submitted, or DAR may have been submitted. So the question is the Motor Accidents Claims Tribunal at Guwahati would inquire with the Motor Accidents Tribunal wherein the accident happened. And thereupon, if there is no DAR submitted, then the Motor Accidents Claims Tribunal at Guwahati will direct the officer in charge under whom the accident happened to submit the DAR before it. I think this
that
is
the problem.
some form of way that is which can be done. And if that is done, then I think this problem with 166(3) can be taken care of. 2 o'clock. You think about it.
Can it be, lordship, can it be taken on Thursday, my lord?
Okay, Thursday. Thursday, 2 o'clock.
Lordship, I will inform.
And ask your Mr. D. Nath. If he does not appear, we'll ask the Commissioner and Secretary.
Lordship, I will inform. Lordship. Much obliged. Lordship.
It has been submitted that an additional affidavit has been filed on behalf of the state government. Post of the same, however, having not come on record, list the matter on Thursday, date to deliver at 2 p.m. 2 p.m.
So please. Motion.
Please, Your Lordship. Lordship, we are agreed by the award passed by the Labour Court, wherein the respondent number 3, he was reinstated back into my industry with 50% back wages. Lordship, facts in brief is that respondent number 3 was an electrician in my factory, my industry.
Huh?
Respondent number 3, he was an electrician in my industry. He went off the radar for 50 days. As per his version, he had informed certain employees of the company, but that was not authorized leave as per certified standing orders. He came back after 50 days. Now, Lordship, the certified standing order, if your Lordship will kindly see page 38. Clause 11 very specifically says that if you are off the radar, if you are not appeared for 10 days continuously in the job, you will be considered to have voluntarily abandoned your service. There will be no termination on the part of the employer. It will be considered as voluntarily abandoned. He is deemed to have voluntarily abandoned his service. So their claim is that natural justice was not followed.
Huh?
And that natural justice was not followed. In fact, the Labour Court does not even discuss this aspect of the certified standing order, clause 11 or any mention of the certified standing order. The Labour Court also goes on to reflect that natural justice was not followed, and on that pretext, respondent number 3 was reinstated with 50% back wages. Lordship may take reference to page 113, the award, the operative part of the award.
So here is a case that you have terminated him, you have dispensed with his service
Lordship,
on the ground that he had absented himself for 50 days.
50 days, continuous.
And the standing order stipulates that if a person absents himself for more than 10 days
Hence,
without due information, it would be deemed that he has voluntarily abandoned his
yes, sir.
service. So therefore, there was no requirement of any disciplinary procedure. Question, misconduct does not.
Lordship,
The misconduct concept will only come in if it is a case that, because here, although I could see in paragraph number 6 of the judgment, there is a reference to a misconduct, but here it's not a question of misconduct, but it is voluntarily giving up his job.
Lordship,
So therefore, there is no requirement of any departmental inquiry.
Lordship.
That's your case.
Lordship. In fact, so far as termination is concerned, they have a very specific clause. that
Let's see
deals
the
with
standing
termination.
orders.
Standing orders, Lordship, I will rely on page 38.
Page.
38.
There's so many judgments given.
Yes, on the last occasion, Lordship.
38. It has come up for hearing.
Lord. Otherwise, admission, Lordship, as per the
Okay.
clause list.
Extension of leave. In the event of a workman applying for an extension of the period of his granted leave, he shall make an application in writing to the manager well before the period of the original leave. A certificate of it. 11, na?
Lordship,
If a
11A.
workman remains absent beyond the period of the leave originally granted or subsequently extended, he would lose his lien on his employment and his name shall be removed from the muster roll of the establishment without any notice unless the returns within 10 days, including weekly off and all so and so.
Lordship, B also. Next page, 11B, 11F. These are all relevant to the case.
Remaining absent without leave for a period of 10 days, including so and so or more, at a stretch shall be deemed to have abandoned the service and his name would be struck off without any notice, pay or compensation from the master role of the establishment. In the above circumstances, the manager may consider any satisfactory application for the amount. Now, did he submit any application?
Only his oral, as per oral evidence during the labor court proceedings, he says that he fell ill in between and then he submitted some medical document that was never brought on record. So that was purely oral admission. And section 12 of the Industrial Employment Standing Orders Act very specifically says that any oral evidence cannot be admissible if it is contrary to the standing orders. So even if he had to follow the procedure, Lordship he would have had to follow 10A, extension of leave. He would have had to give it in writing, but that was not
No,
done.
no, understood. Did he submit any explanation? My question is that.
No explanation was submitted. Nothing.
Now, is it a finding of fact arrived at by the learned courts below? That there was that he has submitted explanation?
Lordship, not to that effect. The only pretext of the award was that natural justice was not followed. In fact,
That is okay. That is another aspect. But the question is whether he has submitted the explanation.
No.
And the explanation having not been taken into account properly, that might also be
Yes.
given rise to a.
Yes.
But if he had not submitted an explanation, that he gives up 12C.
Lordship, yes. So yes, 12C. He did not.
Because if he gives an explanation and the manager is not satisfied,
Yes.
and then without hearing him, dismisses his application, no explanation, and it is a different aspect of the matter for which there might be a question.
Yes.
As to whether that explanation was proper or not, that can also rise to an industrial dispute.
Right.
There's no quarrel with that. But the question is, if there's no finding of fact right there by the learned labor court that there was an explanation submitted, so therefore 12B only applies.
Yes. 12C was not.
Yes, Mr. Dasgupta.
No, this is a case of abandonment of service in view of the provision contained in the standing order. Now, for the timing, I invite your lordship to come to provisions of section 200 of the Industrial Dispute Act.
Industrial dispute act, right?
This is the case of termination of service. Now, this kind of termination is called as retrenchment. May I read that?
Just for a minute. Yes.
200. Retrenchment means the termination by the employer of service of a workman for any reason whatsoever. Otherwise, then a punishment inflicted by way of disciplinary action, but does not include voluntary retirement, retirement of the workman, that is not retirement of the workman on reaching the age of superannuation, termination of service of the workman on a result of non-renewal of the contract of employment, etc., etc. So, termination of service of a workman on the ground of continued ill health. So these things are not available here. Only ground is that his services were terminated without otherwise than a punishment inflicted by way of disciplinary action. It is a case of retrenchment. Now, if it is a case of retrenchment, certain mandatory provisions are to be complied with. That provisions your lordship will find at section 25F. After all,
But
it's a
why do
case of,
but Mr. Dasgupta, why do you say this to be a case of retrenchment?
because his service has been terminated. A Supreme Court is also held when a case of abandonment is concerned, it should be considered as a case of retrenchment.
Let's see where.
1993, 3 SCC 259.
DK Yadav.
Your Lordship, come to paragraph 3. This is a case of loss of abandonment of service.
Yes.
I saw it. The Punjab. Now, Your Lordship, in paragraph 4, there are certain number of judgments has been referred. I have brought those judgments. And if we go through those judgments, our idea will be clear. Learning development supply कैसे support कैसे The ratio of the judgment is that to invoke this provision of the standing order, you have to comply with the provisions of the retention. If they want to. And secondly, my lord, principle of natural justice is also required to be complied with.
Now, this judgment in DK Yadav is squarely on the point.
Look, in support of that, so far the retrenchment is concerned, look, I can pass some
No,
other
not
things.
necessarily. Here, he has the Supreme Court have duly taken note of various other judgments
Yes,
and
I brought
Robert-
all those judgments.
the Robert D'Souza and all these
Robert
things. were-
Robert D'Souza, Glaxo Laboratory.
So all these things, it has been held. And it seems to me that the learned labor court had accordingly granted 50% of the back wages on the
Yes,
basis
and
thereof.
in this case also it is 50% was also.
Yeah. So it seems like that. Now, any judgment thereafter
Lordship,
given?
yes. As per my limited understanding, the jurisprudence after that evolved. Till 1993, there were a series of judgments wherein it was held that if there is abandonment, then also it will amount to retrenchment.
Yes.
After that, Lordship may kindly refer to the judgment I am relying on, Vijay S. Satai versus Indian Airlines by the Supreme Court.
Wait, citation again.
2013 judge, 2013 10 SCC 253. Lordship,
Yes,
just
10 SCC.
Lordship, I'll rely from paragraph 9 onwards. 253.
250.
Paragraph 9 onwards, Lordship. May I read the relevant portions?
Yes.
Absence 9. Absence from duty in the beginning may be misconduct, but when absence is for a very long period, it may amount to voluntary abandonment of service, and in that eventuality, the bonds of service come to an end automatically without requiring any order to be passed by the employer. Paragraph 11, Lordship, is critical. 11 very specifically goes on to hold that for the purpose of termination, there has to be a positive action on the part of the employer, while abandonment of service is a consequence of unilateral action on behalf of the employee and the employer has no role in it.
Wait. Mr. Kothari, these are not cases of workmen. This is a case of a deputy general manager. He would not come under 2S.
200, Lordship. Yes.
No, 200 is retrenchment. 2S is workman.
It is a workman.
He would not come within the ambit of
No,
workman.
it is standing under.
He would not come within the ambit of
Yes.
the Industrial Disputes Act. Here you see, these Industrial Disputes Acts were made in such a manner that so that there is some protection being given to the workmen as against the might of the employer. But the managerial people do not get that advantage. So therefore, how will this judgment? Yes, managerial is different. There is no concept of retrenchment in their cases. How do you apply this law?
Lordship may also take note of the interpretation that has otherwise been given in another.
Have they dealt with in this judgment, the 93 judgment?
93 has dealt with, no, not the 93 judgment.
Obviously, the reason
Specifically-
is specific because this comes under the Industrial Disputes Act, whereas this would not. Yes, there is no quarrel. If in a particular service, a private employment, just for example, the Reliance, a person is absent himself for 50 days in a managerial staff, he may be said that it is okay, he will go away. But just for example, a workman who comes under 2S in Reliance itself, and he does not appear, and he voluntarily absents himself. Yes, the standing orders may very well take care of that. But overall, DK Yadav's judgment and all the other judgments duly holds that it is a case of retrenchment, 200, which should not, however, come in the case of that manager.
But otherwise, Lordship, in the trial proceedings before the labor court, firstly, this was adjudicated before the labor court. Labor court does not even have the jurisdiction to deal with retrenchment. Never was the claim ever in the course of the trial proceedings that this is a case of retrenchment. So if it is a case of retrenchment, then as per 5th schedule of the Industrial Disputes Act, it becomes a matter of industrial tribunal. Also, Lordship, may take just note of one judgment that I'm relying on, Manju Saxena versus Union of India. This is the
Just 1
2018 judgment. There they have slightly sought to interpret retrenchment. Paragraphs, Lordship may kindly take note of page 7 of that judgment.
Which one?
Manju Saxena. Manju Saxena versus Union of India, 2018.
Yes.
Lordship, the relevant portion is page 7 and 8. They've just dealt with the concept of retrenchment.
Paragraph?
Paragraphs, Lordship, otherwise it is not paragraph 5.3. It starts from 5.3.
Okay.
5.3 deals with voluntary abandonment of service, which discusses this judgment that I relied on, Vijay S. Satai.
আচ্ছা ঠিক আছে তুমি আর্গুমেন্ট করে যাও পিছাত চালো
Slightly different.
Where, what is this line mentioned out there? Once it is established
Yep.
that the appellant has voluntarily abandoned her service in that judgment, Manju
Lordship.
Saxena, she could not have been in continuous service as defined in 2O. What is continuous service is defined?
Lordship, basically, 2O defines retrenchment,
Right.
25F provides the protection that is available once it is established that it is a case of retrenchment. So in 25F, the paragraph below, here they have extracted that said section. It says conditions precedent to retrenchment of workmen. So here the term continuous has been used.
So you want to pay 69 lakhs to the petitioner? Workman?
Eventually that.
No, no, well, let us apply the same principle then. 69 lakhs. You paid it.
In fact, we've paid in surplus because of 17B. While
No,
17B
no,
was going on.
17B is okay, but says 69 lakhs, similar to that. You see, what was the case here? The case out here, as it appeared, that workmen concerned were given 4 alternate jobs. Then look here, having the same scale of pay, there is no requirement for additional special training out there. And the workman was told that you take up any of the 4. The workman said, no, nothing doing. I am not going to take out that. Even in the reconciliation proceedings, she did not ask for reinstatement. What she asked is for higher compensation. So therefore, from those facts, one can very well discern that look here, this particular person concerned has nothing to do with the job. It is voluntary abandoned and nothing to do with the job. So this is not the facts here.
No, Lordship, if I may, if I may,
Please.
the interpretation.
I always give you the liberty. Please.
Lordship, from what I could understand that continuous service has been defined here. So it says,
We are concerned out here with a 50-day absence.
Lordship, In fact,
whether this 50-day absence can be treated as such, because here 12C also comes in. Now, 12C is an aspect pertaining to natural justice, meaning thereby, if he is in a position to give an explanation, then indeed, in that regard, if he gives a better explanation, the manager concerned can very well look into it. Now, if you don't give him an opportunity to give an explanation, then the 12C is not being taken note of.
he did not bring it on record. It was his duty while he filed that complaint that yes, he has issued this letter or this notice, and then the management did not consider. It is his version. In fact, Lordship.
No, how, you should have therefore issued the notice. Then look here, you have absented for more than 10 days. What is your explanation? If you don't have an explanation, we are terminating you. That's it. That should have been done.
He acted as per the standing order, which said that without notice, it can be done away with. Clause
In the
A and B.
above seven, the manager may consider any satisfactory explanation of the workman for his continued loss of expense and can order for a fresh appointment as substitute or temporary at his sole discretion.
Lordship, one more aspect, page 55. Even the workman is not claiming for reinstatement. He is just claiming for money.
Vijay,
The prayer.
page
Page 55.
35 is what?
55.
55.
Lordship. The prayer portion, Lordship. In the premises above, your honorable court may kindly be pleased to admit this application, pass necessary appropriate orders, calling the opposite parties to appear and to file the written statement along with records of service and last on wages so and so. And after hearing the parties, please determine the amount entitled to the applicants. Though later on, admittedly, they took the plea of illegal termination.
As of now, the reinstatement does not arise. The money is only the question because this was done in 2014
Yes.
when he was 52 years.
Yes. And at the
We are
beginning-
in another 11 now. So 62 is 63. So the question of reinstatement does not arise. So therefore, it is a question of back wages he is entitled to. And giving the 50% back wages, why are you fighting out there?
Yes. That is the case.
Unnecessary fighting doesn't make any sense. Give him the 50%.
And that 50% he can adjust.
Against the 17B, what you have paid.
Came to know much later on, we had
According to-
kept on paying 17B wages.
Huh?
Superannuation, we were paying the 17B
They
wages.
can adjust it.
Understood, but whatever may be, you adjust it, whatever you paid, and if necessary, yeah. So now, therefore, the question of reinstatement does not arise. 17B, which is there, you have been paying out there.
Some amount paid, has been paid.
So any amount which has been paid shall be deducted from the 50% of the back wages. So the question of reinstatement does not arise. So that's it. Win-win for both of you.
That is it. I also done.
The matter shouldn't have gone further. Chalo.
But even if we go by retrenchment, otherwise that was not in labor court, they never raised that plea. That should have been before industrial tribunal. They went before labor court, just legality of it, Lordship. We are challenging the legality. The award did not even discuss the aspect of standing orders. Absolutely blank, Lordship. Not even one mention that standing order clause 11 says this. At least there should have been an attempt.
Who sent it to the labor court?
The workman, Lordship. The workman,
No, was there no reference?
yes, reference was there. The workman had initially,
You make a reference to, you ask the government. The government makes the reference.
Got
It's the mistake of the government, whether it has gone to the industrial tribunal or the labor court. Am I not right, Mr. Dasgupta?
Yes.
It's the fault of the
So, but
government
it
under
can
section
be- it can
10.
be adjudicated by the labor code also. No
The
problem.
labor court or the industrial tribunal, that is another besides the point. So the back wages which is given 50%, the question of reinstatement does not arise. Back wages which is there, you pay him the 50% and deduct whatever amount you have already paid.
It will be beneficial for him.
But don't, if it is more than that you have paid, then the question of recovery shall not happen.
That cannot be.
Heard, Mr.
High Court had.
The learned counsel appearing on behalf of the petitioner. Mr. A. Das Gupta, the learned senior counsel, assisted by so-and-so, who represents the respondent number 3. Anybody? Ms. Udas appears on behalf of the respondent number 1. Okay. The petitioner herein have approached this court challenging the award dated 10/5/2016 in case number 1/15 and reference number case number 2/15. What is that? Where is that tribunal's order? Yes.
Page 106 of it.
Now, there's only one award.
Yes, eventually.
Huh?
Eventually, one award was passed for both these.
What happened
These
is
were amalgamated.
initially we raised an industrial dispute, but it was not referred. So we, at that point of time, we invoked the provision contained in section 2A(2) and straightaway file an application. Ultimately, the government made a reference.
Okay.
And during pendency.
So
of
there
the-
is only one award.
only one.
Challenging the award dated 10/5/2016, passed in reference case number 2/2015 and case number 1/2015.
Understand?
Full stop. The petitioner have also assailed the execution proceedings, being execution case number 4/2016 pending before the court of the district judge Kamrup, Metro Guwahati, which is consequential to the award dated 10/5/2016. Full stop. The brief facts which have led to the present proceedings is that the respondent number 3 was initially appointed as a contract employee by the petitioner company on 5/8/2003, and subsequently his services were regularized as permanent employee on or after, on and from 1/9/2006 with a permanent ESI number 43006955. Full stop. The respondent number 3 took leave on 10/6/2013. No, full stop. It is alleged on behalf of the petitioner that the respondent number 3 took leave on 10/6/2013 without making any formal application as per the procedure of the company. And chose to come back to rejoin after 1 month, 20 days of unauthorized leave. That is from 10/6/2013 to 30/7/2013. On account of the petitioner company, on the basis of clause 12B of its standing orders, of its standing orders, dispensed with the services of the petitioner. Full stop. The petitioner, being aggrieved, prepared an application under section 2A
Within bracket 2.
bracket 2 of the Industrial Disputes Act 1947, for short, the Act of 1947, challenging the said termination of the petitioner before the learned
Labor code. Labor code, no?
Labor Code, Guwahati. Full stop. This application was registered as case number 1/2015. Full stop. In the meantime, comma, the government of Assam, the appropriate government, that is the state of Assam, had made a reference to the Learned Labor Court, which was registered and made a reference to the Learned Labor Court,
It was issued reference case number 2 of 2015.
with the following issues. Where is the reference order?
So I think most of it's not annexed. Just check one.
Ah.
31, 2000.
Made a reference to the Learned Labor Court, which reads as under, number one, whether the workman is justified in demanding more money about his legal, no. What is the reference made? Hey, record to isn't so. Made a reference to the Learned Labor Court, to the presiding officer, Labor Court Guwahati, by the notification dated 19/1/2015, and the issues so referred were, number one, whether the management of ArtFed, isn't it? Is it ArtFed? No.
No, Lordship,
Oh, this is
Kesley
different file. No, why is this ArtFed coming here? Oh, yeah. Reference was made. On 30th of January 2015, will you? Huh? Notification dated 30th of January 2015. Your name is what?
Lordship, Kishle Foods.
Ishle Food. And the issues which were referred were, number one, whether the workman is justified in demanding more money above his legal dues from the management of MS Kishalai Foods Products Private Limited, question mark. And number two, if not, then what relief the workman is entitled to? This court further finds it pertinent to take note of the application so filed by the workman
Four onwards, Lordship.
This reference case 1 of 2015 is some management of Artfed Bamuni Madam. Why is this one?
If I remember previously, some wrong LCR was sent up also, due to which
There is another one, sin petition under so and so oblique 30, এইখন যে file কৰিছে, had filed an application under section 2A bracket 2 ওপৰত লিখিছিল ন, oblique 33C 2 of the Industrial Disputes Act.
Look, this is it. It's a subsequent case. After award.
Huh? It is pertinent herein to mention that in the application so filed by the petitioner under section 2 bracket A bracket 2 capital A bracket 2 oblique 33 capital C bracket 2 of the Act of 1947, which was registered as case number 1 oblique 2015. The case of the respondent number 3 was that the respondent number 3 went to his native Bihar on leave for 1 month from 10/6/2013 with the due approval with an advance payment of rupees 7,000 on kind endorsement of the foreman Binoy Srivastav in charge of the office Ashwini, Vinay Srivastav, in charge of the office Ashwini Goswami, accountant Sudip Datta and cashier Ram Gopal Sharma. Full stop. The respondent number 3 further stated that in Bihar during leave, he had to take medical treatment for on account of high fever on 5/7/2023, and resultantly, he had to delay his return from Bihar, and the respondent number 3 reported to his duty on 30/7/2013 with medical certificate. Full stop. It is the case of the respondent number 3 that the opposite part, that the petitioner company herein refused to allow him to join at his duty, even and imposed restriction of his entry into the premises of the establishment. And the respondent number 3 alleged such a termination to be an illegal termination. It was further alleged that on 10/9/2013, the petitioner company called the respondent number 3 and verbally offered a lump sum of rupees 40,000 as full and final settlement of his claim for reinstatement. Full stop. The respondent number 3 disagreed and moved for settlement through conciliation. Full stop. The authority, labor officer cum conciliation officer of the office of the Assistant Labor Commissioner Kamrup, called the parties and tried to attain an amicable settlement but failed. Full stop. It was further, the relief which was sought for in the said application is that to determine the amount to which the respondent number 3 was entitled to. It is very pertinent also to take note of that as on today, when the instant proceedings is being taken up, the respondent number 3 would be 62 years, isn't it?
More lordship.
No.
Yes.
52 and 2014.
65. 65.
How?
In 2013, he was 52. Now it is.
No, 2000 December, 26 December 2014. He said to be 52.
Because as per ESI.
As per service record is how much?
As per service record lordship, it should be 65 because
Would be 65.
on 1 October 2019, he attained 58 and hence his age of superannuation.
Okay. So
On
would be
October
65. Just- As per relevant to take note of that the respond number 3 as on date would be 65 years. First. The record further reveals that both the proceedings being case number 1/2015 and reference case number 2/2015 were consolidated by the learned labor court. And thereupon, after adducing evidence, and thereupon, the award was passed on 10/5/2016, holding inter alia that the respondent number 3 would be entitled to reinstatement with 50% back wages. Full stop. It is the finding of the learned labor court that the petitioner company did not give any opportunity to the respondent number 3 to defend himself. Full stop. Not only that, a show cause notice was also not issued to the respondent number 3, which was in violation to the principles of natural justice. Full stop. Aggrieved by the award dated 10/5/2016, the present proceeding passed by the Learned Labor Court Guwahati, the present proceedings was filed on 10/2/2017 after the award was published. Award was published, no? After the award was published. Full stop. The record reveals that by an order dated 24/3/2017, this court had stayed the impugned award dated 10/5/2016. Full stop. Whether 17B is given,
Yes.
there's some I এখন আছে, no? This court further finds it relevant to take note of that the respondent number 3 had filed an application before this court on 8/6/2017. No, on 12/7/2017, claiming the last drawn wages in terms with section 17 capital B of the Act of 1947. And this court, by an order dated 9/2/2018, directed that the petitioner be paid the last drawn wages during the pendency of the instant proceedings, with effect from the date of filing of the writ proceedings. Full stop. It has been submitted that till date, the petitioner is still receiving, and the respondent number 3 is still receiving the last drawn wages.
Not till late. After the point we stop, once we realize that he has attained the age of
Ah,
superannuation.
it has been submitted at the bar that once the petitioner, having come to learn, having realized that the petitioner, that the respondent number 3 had attained his age of superannuation, the last drawn wages as directed by this court in IAC 2345/2017 have been stopped. In the backdrop of the above narration of the facts, the question arises before this court as to whether the impugn award dated 10/5/2016 is required to be interfered with. Mr. Y. Kothari, the learned counsel appearing on behalf of the petitioner, drew the attention of the court to clause 12B of the standing orders insofar as the petitioner company is concerned, and submitted that as the respondent number 3 had voluntarily have absented himself for a period of 10 days without seeking any leave, the petitioner, the respondent number 3 had voluntarily abandoned his services. And as such, it is a case where by virtue of the standing orders, the petitioner have been retrenched, the petitioner have abandoned his services, for which there was no necessity of issuance of any notice, not to speak of any disciplinary proceedings to be initiated. Full stop. In that regard, he has referred to the judgment of the two judgments of the Supreme Court in the case of Vijay S. Sathe versus Indian Airlines Limited, reported in 2013 10 SCC 253, as well as Manju Saxena versus Union of India and others, reported in what is the Supreme Court? 2019 2 SCC 628. Referring to the two judgments, the learned counsel appearing on behalf of the petitioner submitted that as the petitioner have abandoned his services, the question of issuance of any notice whatsoever does not arise, which the learned labor court failed to appreciate. The learned counsel further submitted, drawing the attention of this court to the reference to the application so filed by the petitioner under section 2 capital A bracket 2 red oblique 33C of the Act of 1947, and submitted what the petitioner sought is not a case of reinstatement, but is a case pertaining to additional amounts as would be apparent from the prayer relief so sought for in the said application. The learned counsel further submitted that there is a further submitted that from the very reference so made by the learned labor by the government in terms with section 10 of the Act of 1947, is only in relation to what additional amount the petitioner is entitled, the respondent number 3 is not entitled to, and not is a case and not a case of reinstatement. He therefore submitted that the London Labour Court had exceeded its jurisdiction in directing reinstatement with back wage 50% back wages. Anything more? Per contra, Mr. A. Dasgupta, the learned senior counsel, drew the attention of the court to the judgment of the Supreme Court in the case of D.K. Yadav versus JMA Industries Limited, reported in 1993 3 SEC 259, and submitted that the instant case is squarely covered by the said judgment. The learned counsel further submitted that in the instant case, the petitioner, the respondent number 3, no doubt had not joined his duty for a period of 50 days, but he had duly intimated his immediate superiors, and would be seen from the application so submitted. This aspect of the matter was also proved during the proceedings before the learned Labour Court. The learned counsel further submitted that the principles of natural justice duly applies to the facts of the present nature, and if a notice in that so-called notice would have been issued, the petitioner, the respondent number 3, would have been in a better position to explain the reasons why the respondent number 3 could not attend his duties immediately. The learned counsel further senior counsel further submitted that the respondent number 3 further submitted that the petitioner company, the management of the petitioner company even then did not let the petition respondent number 3 enter the premises. And as such, the petition respondent number 3 could not provide an explanation which right he had to provide in terms with clause 12C of the standing orders itself. The learned counsel further submitted that this is a case of retrenchment as defined in section 200, small, 2000, of the Act of 1947. And if it is, as it would be very apparent from the judgment in the case of D.K. Yadav Supra, taking into account the similarity of the facts involved, and further, and if it is a case of retrenchment, the mandate as provided in section 25F of the Act of 1947 was required to be followed. He therefore submitted that this is a fit case where this is not a case wherein this court would exercise its tertiary jurisdiction. Anything more? Analysis and decision. From the materials on record, it would be seen that the petitioner the respondent number 3 had absented himself on from 10/6/2013 to 30/7/2013. There's no dispute in that regard. It's the case of the respondent number 3 that he had informed his immediate superiors that he would be going to his native place at Bihar for a period of 1 month. But on account of falling ill, he had to undergo a certain treatment, which resulted in the respondent number 3 taking which resulted in the respondent number 3 joining the establishment of the petitioner only on 30/7/2013. The establishment of the respondent number 3, petitioner, however, relies upon clause 12B of the standing orders, which reads as under page 40. From a reading of the above quoted clause in the standing orders, you are referring to which clause?
Lordship 11A, B and F.
Oh, 11B, 11B, yeah, 11B, 12B, no, 11B. Huh? I got to 11B, yes. Up page 39 of this. A perusal of the above clause would show that if a workman remains absent without leave for a period of 10 days, including weekly offs and all types of holidays, bracket close, or more at a stretch, the applicant, the workman shall be deemed to have abandoned the service and his name would be struck off without any notice, pay, or completion from the or compensation from the master role of the establishment. This court further finds it relevant to take note of clause 11C, which is reproduced here in under page 39. A perusal of the above clause shows that there is an opportunity provided in the standing orders itself, which permits the workman to provide an explanation for his absence. Nothing has been brought on record on behalf of the management of the petitioner that such an opportunity was afforded to the petitioner. Rather, it is the specific case of the petitioner was afforded to the respondent number 3. First. Rather, it is the specific case of the respondent number 3 that he was not even permitted to enter the premises after 30/7/2013. First. In the opinion of this court, this opportunity which the workman oblique the respondent number 3 had in terms with section clause 11C is a valuable right conferred upon the workman to explain his unauthorized absence. First. Next. This court further finds it pertinent to take note of that take note of the application so filed by the respondent number 3 under section 2 capital A bracket 2 oblique 33 bracket capital C of the Act of 1947, which have been registered as case number 1 of 2015. In the said application, the respondent number 3 have not sought for reinstatement. Rather, what the respondent number 3 had stated, that he was offered a lump sum of rupees 40,000, which the respondent number 3 did not agree and sought for a determination of the said amount by the learned labor court. This court further finds it very pertinent to take note of the reference which was made by the government of Assam, which being relevant, and the reference which was made, and the reference so made by the by the government of Assam to the learned labor court, by notification dated 30/1/2015. The questions which were referred were, inverted comma, whether the workman is justified in demanding more money above his legal dues from the management of MS Kishalai Food Products Private Limited, question mark. Number 2, if not, comma, then what relief the workman is entitled to, question mark. From the reference which have been made and the application which was filed, reference so made from the reference so made by the government of Assam and the application so filed by the respondent number 3, cumulatively shows that the respondent number 3 was more interested in the amount in the form of compensation or otherwise on account of illegal termination rather than reinstatement. Full stop. In the backdrop of the above factual facts, this court now finds it relevant to take note of the judgment of the Supreme Court referred to by the learned counsel, senior counsel appearing on behalf of the respondent number 3. That is the case rendered, that is the judgment rendered in the case of D.K. Yadav Supra.
Paragraph 16, last paragraph. %50 of the benefit.
In the same judgment, it is pertinent now to take note of the brief facts which led to the judgment rendered by the Supreme Court in the case of D.K. Yadav Supra, wherein the workman absented from duty for a period of 8 days continuously. And in terms with the certified standing orders, the workman was held by the management to have lost his lien on employment. It is relevant to take note of that the workman therein had submitted an explanation. Which was not taken into consideration by the management therein. And in that context, the Supreme Court held that the termination of the workman for his absence amounted to misconduct and termination, misconduct. And such termination had to comply with the minimum principles of natural justice. The Supreme Court further held that as there was no opportunity so granted to the workmen therein, and there was no inquiry held, comma, and there was a readiness on the part of the workman therein to join his services. There was a direction for reinstatement of the workmen with back 50% back wages. This aspect of the matter can be discerned from a perusal of paragraph number 15 of the said judgment rendered by the Supreme Court in D.K. Yadav, which is reproduced here in under. তাতে এইটো যেটা reproduce কৰিব তাতে এটা line এটা আছে হা second line that the appellant's plea put forward at the earliest was that despite his reporting his duty and on all subsequent days and readiness to join duty he was prevented from remand nor was he permitted to sign the attendance register. Itu underline কৰিব তাত তলত লিখি দিব emphasis supplied on the above noted portion. Full stop. The relief so granted by the Supreme Court can be seen from paragraph number 16 of the said judgment, which is reproduced here in under. Full stop. Next. In the backdrop of the above, it will be seen that the learned labor court in the impugned judgment, in the impugned award dated 10/5/2016, applied the said principle as held by the Supreme Court in the case of D.K. Yadav Supra and granted the relief of reinstatement with back wages, 50% back wages, irrespective of the fact that the respondent number 3 never sought for back wages, nor the reference so made by the government was in relation to any back wages, a relation to reinstatement. Next. The learned counsel appearing on behalf of the petitioner, though, have referred to the judgment in the case of Vijay S. Sathe, reported as Supra. But in the opinion of the court, the said judgment would have no relevance, taking into account that the said petitioner therein was working as the Deputy General Manager Operations, which would and such person under no circumstances would come within the meaning of section 2S of the Act of 1947 to be entitled to the benefits in terms with the Act of 1947. This court further finds it relevant now to take note of the judgment in the case of Manju Saxena Supra, which throws some light in respect to what relief this court can grant in the present facts. First, it is an admitted position that today, as on date, the question of reinstatement of the petitioner, respondent number 3, does not arise, taking into account that he has already crossed the age of superannuation. First, this court further finds it relevant to take note of paragraph 5.3 And the relief which have been granted in paragraph 5.4, is it 5.3 or 5.4 in the SCC or not?
Lordship,
You are giving this Supreme today. I don't go by these things. You are a young advocate. Give better citations. Don't give me with these citations. I don't go by these types.
uh, 2019 to SCC 628.
That I know. Relevant to take note of paragraph 6.3, 6.4, 6.5, 6.6, 6.7. Relevant, finds relevant to take note of paragraph 6 and its subparagraphs. Which, being relevant, is reproduced here in under. And again, paragraphs 6.3, 6.4, 6.5, which is being relevant is reproduced here in under. The facts, the findings so arrived at. But the Supreme Court, in the case of Manju Saxena, and more particularly in the above quoted paragraphs, shows certain similarity in respect to the case of the respondent number 3 herein. In as much as what the respondent number 3 sought for is as regards a higher determination of a higher amount on account of illegal termination rather than reinstatement. This court further finds it relevant to take note of that the Supreme Court in the case of Manju Saxena, having taken in note of that the workman therein, having already received a higher amount than what the workman actually had claimed, observed that the amount which had been received by the workman therein should be deemed to be the full and final settlement. Applying the said principles as laid down, as there is no question of reinstatement of the respondent number 3 today as on date, and This court further taking note of that the respondent number 3 have already received certain amounts in the context of section 17B, capital B of the Act of 1947. Would not like to interfere with the observations made by the learned, with the directions so given by the learned labor court in the impugned award insofar as direction to pay 50% of the back wages. However, the question of reinstatement direction for reinstatement requires interference. And however, this court would not permit
Does not arise.
would not. However, in the present facts, the question of reinstatement does not arise, taking into account that the respondent number 3 as on date have crossed the age of superannuation. First, accordingly, next, the instant writ petition stands disposed of with the following observations and directions. Number 1, the non-affording of the opportunity to the petitioner to give an explanation in terms with clause 11C of the standing order amounts to violation of the principles of natural justice. First, B, the termination so made as regards the petition, next, as there is a violation, the violation of of the principles of natural justice, which is a facet of Article 14 and 21 of the Constitution, being writ large, this court holds that the termination of the petitioner was illegal. Number 3, of the respondent number 3 is illegal, number 3. The respondent number 3, on account of having crossed the age of superannuation, would not be entitled to reinstatement. Number 4, the respondent number 3 would be entitled to back wages till the date of his superannuation at the rate of 50%. The amounts so paid in the meantime, if any amounts so paid, by the respondent number, by the establishment of the petitioner, shall be deducted while computing the amount to which the respondent number 3 would be entitled to, number 4. If it is found that any amount that the respondent number 3 had got more amount than what the respondent number 3 is entitled to, there shall be no recovery. First, number 5, this court further directs that if in the circumstance it is found that the respondent number 3 is entitled to certain amount, the said amount be paid to the respondent number 3 within 60 days from the date of the judgment. There shall be no order as to cost. Send back the records. Plus 2017 matter goes. Only that matter is there. That matter I'm just keeping it so that. Yes, what is this?
Make the lordship, the petitioner was allotted LOI, letter of intent for a San Mahon, page 14 annexure A for 7 years for a successful bid of rupees 41 lakhs. That is at page 14 annexure A. Thereafter, my lord, he deposited 11 lakh 61,680.
Mr. R. Gogoi, you were asked to produce the
Yes,
NIT.
Your Lordship, we asked for the original records, Your Lordship. A week's time we will give their financial, because it's
What is
2013
wrong?
NIT.
Huh?
Yeah, 2013 NIT, Your Lordship. It's a very old NIT. So we asked for the original records where they contain all the payment schedule has to be made. And as there was another direction, whether any mining activity is going on in that mining area. We have the instruction that there is no mining activity going on.
Okay, Mr. Chaudhary, what is your case?
My lord,
It's a forfeiture.
my lord, now the impugn order comes, my lord, at page 24. In between, my lord, there was a writ petition filed by some other party at page 20 and obtained a stay order.
With reference to the above cited above, you are hereby informed that you have deposited 4 lakhs so and so as 10% initially in connection with the Boca or ordinary so and ask you to deposit the unpaid 15% with security to make up the 25% of the same, but you have failed. Why action should not be taken against you under 37A? Please explain within 6 weeks. 6 days. Then
My lord, in between, my lord, when
deposit
after LOA was issued,
10%, 1 month demand of in connection with the was filed by so and so. Demand filing was not issued in favor of the petitioner. At present, myself has been suffering from severe disease. Also, I have faced financial demand. Therefore, I request the lieutenant to honor demand to release the fund. So you want the return?
return, because my lord, from the page 20, your lordship will find some other person approached this court by a writ petition in 2014
Ah.
and obtained a stay order.
Then
Then, my lord, it was dismissed. My lord, at page 21, your lordship will find that the divisional forest officers informed me in 2018. For 4 years, it was stay order was there and it was dismissed in 2018. So from,
where's the order of dismissal?
my lord, in page 21, your lordship will find the divisional forest officer informed me.
Has been disposed of by the Iman by then dismissed. In that regard, I'd like to inform you that you are the LOI holder of so and so. Number Iman requests you to obtain the mining plan. Okay, then
My lord, thereafter, my lord, I made a representation at page 22.
page.
22.
Ah,
With refer, I have to inform you
with
that.
effect, I have the honor to inform you the letter of intent granting mining in respect of so and so was issued to me by them. The letter under the asking me to deposit 4 lakhs. so and
Total
so.
11 lakh 61,600.
Then,
Thereafter, my lord, that impugn order comes over.
now then you deposited these amounts.
And I deposited 11 lakh 61,680.
How do you know?
Well, page 22, your lordship.
4 lakhs, 4 lakhs and 3 lakhs.
My
Okay,
lord.
then
And their order itself says that I have deposited that amount at page 17. Your lordship will find
page
17, 17.
you. This is in 2014.
14.
You
14.
deposited on receipt of the amount of being the 10% initial bid security. Then,
My lord, I was asked to start the process of preparation of
Okay, then-
environment. Thereafter, my lord, at page 18, your
page
lordship.
24, it says that you were informed that you have deposited 4,10,000 as 10% initial bid.
And page 18, your lordship will find.
10% of the annual contract money. Then additional 3% of the annual contract money, 10% against mining development. Okay. 10% of Iman, you have deposited 4,10,000. Okay. At 10% of the initial bid in connection with the Boca and ask you to deposit the remaining 15% bid security amount of rupees 6,15,000 to make up 25%. Yes, then
My lord, against that order, I approached this court because for this 24 order, against that order, I approached this court and there was a stay order not for proceeding against this order. So, my lord, that way they have filed an affidavit only in the year.
no, it's okay. But
24.
you see, as per the tender condition, you have to deposit 25%.
No, my lord, the rule provides, my lord, 37.5.
I'm not concerned with the rule. What does the tender condition say?
A tender condition is that why the record was called upon.
I'm not on that. let us not go by them. Are you saying that it is only 10%?
My lord, here, if I understand from 37, what they are relying upon, my lord.
As per in your petition, what do you say? Because here they say, we're informed that you have deposited in money of the human connection and you were asked to deposit and you are to deposit 15% bid security.
Bid security in pursuance to
Now tell
37.5.
me, Mr. Roy Chaudhary, from 2014,
My lord,
there was a stay till 2018.
in 4 years.
Now 2018, you were given the LOI.
LOI.
For how many years?
My lord, because it was total, 13, it was given for 7 years. So, my lord, 13 to up to 2020. My lord, till 18 for 4 years, from 14 onwards, because I could not start anything. 4 years it was stopped.
I'm asking you for how, was it only till 2020,
20, up to 27 years.
not beyond that?
Not good.
This LOI which is stated, your lordship, LOI is issued after the stay order was vacated.
Was it for 3 years or 7 years?
That LOI they've not annexed, but then for 3 years or 4 years. they have
7
not
years,
annexed.
7
Then
years.
It was at 7 years. The
No,
LOI.
no,
minus 2 years.
LOI which has been issued, here you see,
7 years. Page 14.
is 22. Not this. This is a letter written by you.
My lord.
I have deposited this. Now here there was a direction here. LOI of so and so. In this regard, I'd like to inform that you are the LOI holder of so and so unit and request you to obtain mining permit and so and submit the same to the office immediately for necessary action.
That is, your lordship is reading page 24,
21.
21.
Now there,
Because the LOI was issued in 2013, page 14.
Ah.
And that was for 7 years.
Hmm.
Thereafter, my lord, it was issued on 20 December 2013. Tag end of 2013. In 14 January, they informed us that you have received 11,61,680, page 17. And thereafter, there was a stay order. 17 and 18, you also will find that they have informed me that they have received 11,61,680.
what is this document at page 15? This is
That-
typed out in Excel.
Typed out, my lord.
What is this? Let us see the rules.
Rules, my lord, your lordship will find 37.
Mine and minerals.
This book.
Some mining concept.
আছিল এখন misappropriate করা হয়েছে।
Seven and
Take his book.
six.
No, let him have that book. এটা ইয়ার উপরে এখন না। কোন নাই নেকি ইয়াত? ইয়াত কোন আছে? এই নাই, হ্যাঁ। এটা হলো খুব ঘুরি ঘুরি।
37, my lord.
The process for completion of various stages of payment as specified on completion of the bid process, that is fall of the hammer on the opening of the SBR, case may be, the highest bidder shall deposit an amount of ₹10% of the annual bid amount as initial bid security before, okay. The amount deposited here would be adjusted against the bid security on acceptance of the What do you say about 37.33?
My lord, 3 is a process for number 2. That is 2 says the highest bidder shall require to deposit an amount equal to 25% of the annual dead rent, contract money as a security, along with an additional amount equal to 1 month's dead rent, contract money in advance. That is, I have paid.
No, no,
Now,
I'm not on that. What do you say? You see, you have to, as per 37(3)(1),
my lord,
you are to deposit 10% as initial bid security.
well, that I have paid,
This you have then 4,10,000.
my lord.
This initial bid security as per 37(3)(2)
My lord,
would be then brought if you are an LOI.
my lord,
That amount will be adjusted against the bid security.
my lord.
37 Roman 3 say that there will be an additional 15%.
15%.
How do you, that is what being
This
asked.
15% on the time provided to me, period allowed. And the impugn order also
The
says
letter of intent holder shall deposit the balance amount,
balance amount,
means above this 10%,
10%,
which makes it 25.
25.
Why do you need the tender? This is the law.
My lord, I understand this is the law, my lord. 3 says the letter of intent holder shall deposit the balance amount of bid security that is equal to 15% of the annual bid amount before expiry of the period allowed. Now I take your lordship to the order, impugn order and the period allowed.
Hmm. Hmm.
My lord, your lordship will find here that order of 19th January 20, no, this order, they at page 24, your lordship will find
Hmm.
this office letter dated in number 2 reference. Domoka Sandman, dated 12/11/2018. 12/11/2018, that order was not provided to me. Under that order, the period was laid down. Now this impugn order comes on 5/12/2018.
Hmm.
That order of 12/11, I don't know what was the period provided to me. And in the meantime, my lord, prior to that,
No, 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 no. Prior to that,
I have deposited
no,
all
no,
the
no, your letter dated. Where is that letter of 7/1/2014? Your letter dated 7/1/2014. You say this letter, I don't know the date. This is of 16/1/2014. Now, prior to this, there is another letter as per the office letter dated, where's that 12/11/2018?
Well, that order was not provided to me. The period was not provided because the order which was provided.
Where have you mentioned that letter is not provided to you in your communication at page 25?
Well, there
That's good. You see, after the litigation, you were allowed to, now you are being allowed, informed that, look here, the litigation has ended. Now you go ahead with the mining plan and whatever. Then comes thereafter a letter of 12/11
further, Your Lordship, may submit, at page 18, Your Lordship. At page 18, it clearly says only being 10% initial bid security. He has
No, that
deposited.
I'm understanding.
Yes. And we are not asking from the pay us a case money. That's the amount you have to pay when you get.
Why do we need the tender now?
My lord, records, your lordship, as your lordship has found out, but I have deposited 11 lakhs total.
We are not concerned with the other two amounts.
My lord, that what I am praying for, that amount, let them forfeit my 4 lakhs. Balance about that,
No, who is going to pay the 6 lakhs?
my lord, because then, my lord, if total,
You will be entitled to only 1 lakh. Because of the fact, otherwise you pay and take back the 6 lakhs. Or say 8 lakhs.
What?
7 lakhs you take it after you deposit the security bid.
Bid secure, 25% he has to.
if I
completely pay.
deposit the balance 15%, whether that I will be entitled, because I have not been able to.
Then you will be entitled to those two amounts. Huh?
Those,
He will be entitled to 3,41,000 and 4,10,000.
I will be entitled to 4,10,000 and my lord 3,41,000.
But what about the interest?
Not here as well. As
the
we got
interest,
interest,
Your
there is a
Lordship,
charge.
applies when you are defaulted in paying the case money. Your
No
Lordship.
interest whatsoever shall be payable on the security amount deposited. That is what is laid down here. But because they, for 4 years, they have not been able to, from the time when the LOA was provided, the case was hanging over and nothing has been done. So for 4 years, I have suffered already. Now, at 2018, at the fag end of my LOI, the period, they have come and said that you deposit another 15% and you work for. What about?
No, obviously, that has to be issued, given by you as per the law.
But for what happened for this 4 years? Was it not also their duty for 4 years to return back my money? Was it that period? That's my.
Mr. Roy Chaudhary, whether because they don't need to deposit it because this no interest will be there in the security deposit.
Well, interest I'm not asking for, but the amount other than the security
No,
deposit.
where is the question? Then did you say that okay, I'm giving up because of the litigation? Did you say that at
Well,
that point of time?
My lord,
Why were you keeping it at hold?
my lord, in lawsuit you'll find that representation made by me and they informed me as regards in 2018 only.
Obviously, what were you doing in the litigation? Why you are not fighting it out?
They have
Even they had an option for surrendering, even they have an option for surrendering and also.
Yes. What you are challenging now?
that input order of page 24.
This, you are page 24.
Page 24.
But they have not till now forfeited.
Or they have not forfeited because there was an interim order.
Interim order is there, we can forfeit.
Because now the situation.
No, what they are asking, I don't need to go there. Why should I go there? As per 37.5, they are right. You have not deposited it
Yes,
because you have not denied 12.11. So at 2 o'clock we'll dismiss.
Malad, at least one, your lordship may keep it parted. Your lordship,
No, 2 o'clock dismiss.
Malad, your lordship, that opportunity, if I can deposit and get back my money. Our, your lordship
That
may,
is your thing. Why should I say anything?
Malad, that instruction, Malad, your lordship may give that after deducting from that amount, whatever balance amount is there, that may be paid to me. That way also can be done. Because I have deposited 11 lakhs. Malad, what they are entitled to get, let them deduct that amount and balance amount they will pay to me.
What about the interest?
For interest, interest as your lordship will find that if they ask for an interest, they have issued me an order.
No. The interest is statutory. Kindly see 37.56.36. I'll come back. I get your point, what you are asking. You are saying that I give them that 6 lakhs, they give me the 7 lakhs.
Right.
That is what you are saying.
And
But why should I say that? I'm only concerned with 37.5, whether the action initiated under 37.5 is good or
But-
bad.
But that, that amount, extra amount that they have kept it, that extra amount for after the other than 4 lakhs, they have kept 7 lakhs with them, my lord.
You claim interest on that. On that you claim interest.
That
Why should I say? That is not a part of my duty. I am on 226, not 227.
my lord, at least that
Let me come back at 2.
permit me to make one subject to correction now. That from 14 to 18, 13 December, it was LOI was given. So 14 to 18, there was no extraction. And that 41 lakhs and 4 lakhs for 10% was for the period 7 years. Was for the period of 7 years. It's an admitted fact. 18, it got dismissed. Then they say that already that period is over. They also came to know. And 18, they issued me a letter saying that you deposit the balance 15% of the same amount. Whether that will be an unjust enrichment, because they should have apportioned the amount and given to me. Whether the same amount I would, because there was no extraction on my part. Now, whether that amount that they will collect from me, it will be not an unjust enrichment, because it's an admitted fact that 4 years, no extraction. Even for a single day, I was not been able to extract. Nothing was done by me. And at the end, after the impugned order was passed, I just submitted that I won't be able to do any further work with the LOI. That was later on 28, 2018. On the peculiar facts and circumstances of this case, madam. For that 41 lakhs was for 7 years, and 10% of 4,10,000 that I have deposited, 10% that I have deposited, with the balance amount of another 7 lakhs. So 11 lakhs was with them. Now, suddenly, madam, whether that amount to an unjust enrichment by them, madam.
The problem arises because you have enclosed the annexures in a wrong manner. You see why I'm saying. Kindly come to annexure F, page 21.
Madam.
This is of 36, 2018. But you were informed that, look here, now LOI is to be given to you and mining contract is to be given to you. Okay? So immediately thereafter, after 2 months, you write the letter of page 25.
Madam.
That you are not willing to go ahead. Thereupon, they initiate the proceedings that this amount you have paid and remaining you pay.
15%.
So the question is, can you be forced to do so? That's your case. All happens because why you have enclosed annexes J, G, J. Why this is in this manner it has been.
Because of my inexperience, madam.
There is no question of inexperience. We impose a cost on unprofessionalism that they have imposed a cost of 25,000 on a lawyer. Again, another 25,000 on the lawyer.
Sorry for that, because madam, I'm sorry for that, madam. The only thing is that if
yes, Mr. Argo, the question is here. There's a stay for 4 years.
Yes.
Now, if it is a stay for 4 years, you are not going to give him for a further period of 7 years. You are going to give him only for a further period of 2 years. Now he comes up and says to you that, look here, there has been a stay all along and I have not been able to operate. Now I am not in a position to operate. So you don't consider that fee. Rather, you say, now you pay this amount.
First, Lordship, the stay order was given effect after he was the highest bidder. As per 37, June 37, A highest bidder has to pay 25% amount of the security bid. He deposited 10%. 15% remains. So we are not asking him to deposit the KISS money. We are just asking him to deposit the security money, bid security money. That's it.
No,
We're not-
why you are asking? Because now he doesn't want to do it. Now tell me, what are the terms in which a person can withdraw?
There's a provision for surrender application, Your Lordship.
Now, have you considered his plea?
Because he hasn't approached for a surrender application with us.
No, when he submitted his surrender,
No,
Annexure
he has
J,
not submitted.
this is Annexure
No,
J.
This is not a surrender application, Lordship.
Annexure J is a surrender.
No,
What does he say?
it just says that, it's merely says that, I have to inform you that I am the LI holder of Doboka Senma, I will
Now
deposit.
kindly come to the third paragraph.
At present, myself and my son have been suffering with severe disease. Also, I have faced extreme financial loss in business, and at present, I'm not able to operate. It's not that I'm not surrendering. It's saying I cannot operate. As and there is a rule for, there is a provision for surrender, Your Lordship. Rule 21, Your Lordship.
Now, what have you done after 2018? His letter?
We have there after submitted letter, we asked him to ask him to deposit that remaining 15%. Thereafter, he came before this court. There's a stay. So when he proceeded with that, we have not proceeded anything against him, Your Lordship, till now, because an
No,
interim
not
order-
against him, it's okay. But what have you done to the Sen Mahal?
The Sen Mahal is lying idle. We're not putting.
Why?
Because most probably right now, Sen Mahal of more than 5 hectares has to be put on sale, Your Lordship. Most probably this is not more than 5, this is 4 hectares, Your Lordship.
Understood. So this is 4 hectares.
4
So you
hectares.
cannot go for.
We cannot go for, we can only give it to as per Rule 5 to a government development projects, Your Lordship. The Sen Mahal, there is no mining activity going on in the Sen Mahal.
Because it has to be 5 hectares.
5 hectares.
So this cannot be put to
This
re-auction.
can be re-auction because it's as per my knowledge, this is 4 hectares.
Where?
They have not annexed it, Lordship. That's a verbal in it, 4 hectares, Lordship.
Where is it given that it has to be 5 hectares?
Rule 24, Your Lordship.
Rule?
24. H 260. grant of permits for mining over area less than 5 hectares. Subject to sub-rule to rule 20, permits of mining of minerals may be granted by the company authority for extraction of mineral minerals in respective areas ordinarily less than 5 hectares.
So this tender was issued when,
2013,
before these rules came in.
before this, before these rules came in. And thereafter, there was a Supreme Court order where it says that 5 hectares, you cannot go for this auction. It's 5 hectares. Less than 5 hectares, you cannot go for auction. The area has to be more than 5 hectares.
So when was the tender notification?
My lord, rule came into effect from 16/3/2013, and the LOA was given on 20 December 2013. Rule came on, published in Assam Gazette Extraordinary on 16/3/2013.
Then in that regard, if you can allot these 4 hectares to him, because it is contrary to the rules,
Contrary to the
would
rule.
you be in a position to take this if it is a nullity?
The rule came on 16/3/2013. And the tender was of
LOA was issued on 20 December 2013.
20 December 2013. LOA was issued.
Then
Thereafter, in between,
how can you issue a LOA for 4 hectares? How do we know that it is 4 hectares?
that's the issue, Your Lordship.
Because here you see, subject to the appeal provision and other provisions of the Assam Minor Mineral Concession Rules, LOI, is reached with these rules. If it is less than 4 hectares or 4 hectares, this could not, this is in the teeth of the rules.
When the NIT doesn't states about the quantity which the mineral holds a lot.
No, you have to see, that is why my question is, why you have not been able to go for a fresh tender? Yeah, to the preparation of, you have the mining plan with you?
No, my lord, I don't have it. Other than these documents, I don't have it.
No, this enclosure to Annexure D. Sale notice, LOI. You get your instructions on this mahal, on this aspect. Then if it is so, if the entire tender process was in the teeth of the rules, then how can you claim any amount? You'll be entitled to the refund of the entire amount. Because you cannot be allowed to take an action which is beyond the purview of these rules. If it is more than 5 hectares, it is okay. Because this will be in the teeth of the Supreme Court judgment,
Yes, sir.
as well as the Rule 24.
If it's more than 5 hectares, it's okay. If it's less than 5 hectares, how can they put that same?
So then he'll be entitled to the refund of entire thing. Not only 4 lakhs. You also find out this LOA.
Because the NIT, which I just received just now, that doesn't speak about this area.
Then why have you not been able to go for a fresh tender after 2020?
That's the reason I refunded. Why didn't I put that sale on auction?
I seek any specific instruction in that. Get it from your department.
Very well.
Why you have not been able to go ahead with the tender fresh after 2020? They will give an answer to that unwritten. Whether it is 3 hectares, or 5
4.
hectares, or 4 hectares. If that is so, then we take it up. Whether consequential actions will take it.
This one.
Tender was issued on 9/9/2013. Tender was issued at page 18, which is there.
Understood, everything is understood. So the question is why this was not given, whether this is an important aspect.
This one.
What is the area?
Area.
If it is less than 4 hectares, because this will be there somewhere. And in the meantime, if you can find out anything to that effect, put it by way of an additional affidavit.
The mining plan would have consisted the area, the complete area, the mining plan, your lordship, but he has not obtained the mining plan, but we'll get it from
No,
department.
no,
of
he had submitted for a mining plan. This is Annexure D, kindly see.
It is there, madam,
It's
enclosed.
the DFO who wrote to the director for,
This is what has been given, na? For therefore, I request to prepare a mining plan in connection
Connection.
with the Bogas and Mohol on track area outside of area of of which related documents are enclosed.
That was a letter for divisional forest officer to the director geological and mining. So the director of geological and mining have that.
No, copy is given to you.
Oh.
You see, they don't, Mr. Roy Chaudhary, I also know, you also know, they also know. This, the direct divisional forest officer would not sign a document unless you prepare and give it to him. Isn't it?
yes. My lord held in one matter, yes.
Huh?
He held in one, like, held in one matter that the petition didn't approach this geology and mining for this mining plan.
So you have to, because that is why you have been asked to submit your mining plan. Now, heard Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, and Mr. R.R. Gogoi, who appears on behalf of the respondents. The petitioner herein have assailed the communication dated 5/12/2018 issued by the respondent number 4. Whereby the petitioner was asked to show cause as to why action should not be taken against him in terms with Rule 37 Roman 5, 37(3) Roman 5 of the Assam Minor Minerals Concession Rules 2013. Within 6 days from the issuance of the said letter. Full stop. This court, while hearing the matter, inquired with the learned counsel appearing on behalf of the respondents as to whether the said Mohol, that is, the Doboka Ordnance Sen Mining Mohol, number 1 Mohol, had been put to sale after the issuance of the communication by the petitioner on 28/2018, which was duly received by the respondent number 4, respondent number 3, a divisional forest officer to respond number 3. Full stop. Mr. R.R. Gogoi submits that he would obtain instructions in that regard as to whether the said Sen Mohol have been put to sale subsequent to the communication issued by the petitioner on 28/2018 or after the period of completion of the settlement, which falls in the year 2020. List this matter again on 5th of August 2025 for further hearing.
Let it remain part, Malad.
Why?
Malad.
Because I have said something which
No, Malad.
which you have not put in your
Prior to
petition.
1 o'clock, Malad, you have Lordship also said something to me. So, Malad, that Your lordship, because your lordship has heard for a long time, my lord.
Not necessary. I have heard on a different, in the first time I have heard on a different angle, and now I have kept put another aspect. Because that is the only way the petitioner can say, because what has happened is, he, after 4 years asking him now to do, there might be many aspects. So the question is, that communication has not been taken into consideration by you. And that document of 12/11/2018
18.
is also not a subject matter, is not placed before this court. Because that document preceded the impugned communication.
Exactly.
Find it out.
My lord. No, lord.
Obliged.
Yeah, although it is a tension matter.
What matter?
CRP matter. Bench, civil bench one.
It will see the order dated 11/6.
As per the earlier order that is respectively.
Okay. Oh, yes, there's a stay by me.
Yes.
Tell me. Are you?
My lord, Mr.
Bona fide requirement is gone.
That is gone, that is gone.
That is not been put to challenge. What is being challenged here is on the question of non-payment of the rent. That's it.
That is the point.
Trial court, what did the trial court do?
My lord, was in favor in regard to both the issues.
Who is the tenant? Plaintiff or the defendant?
My lord,
I'm the tenant, my lord.
he is the tenant, I am the plaintiff, filed suit for eviction.
And he is the tenant.
He is the tenant.
Okay. So the
It was-
defendant's stand is, your stand is how many months they have not paid?
My lord, your lord,
Lordship will get pays 33 trial court judgment. Only for my lord 9 months. And our stand is that we have paid, but they did not issue the receipt. Thereafter, we have deposited before the court.
You have such a good case for bona fide requirement.
my lord, I conveyed to my lord, my advice.
And moreover, the tenant is on the lock and key, which is not paying the rent from October 2013. And as such payable, rent payable till June 2014, that is for 9 months is 5 into a month. Okay. Hence the total amount payable is 2,000 plus, what is 1,000 year? 1,125 is? Okay, he's not a payment from October 2013.
My lord,
Yes,
Now, what is your stand here?
my lord, page 45 is the.
Wait. Ask her to make regular payment. Remember the defendant did not pay any heed to the payments. 13. Not admit to the truth of the money is not paying money. What does the trial court hold?
Page number 45, my lord, in regard to issue number 4.
I have to hold that, my lord. The petition is a defaulter in respect of that 9 months from that exhibit A1, A2 series was not considered because that was not signed by the plaintiff and the landlady. That's why
So did not believe the books of account.
Because it was not signed by the plaintiff.
Now what does the first appellate court?
Page 77. Paragraph 59 only. And deposit before the court was also not true.
So the defendant or the petitioner herein did not prove the fact of deposit in the court also.
They're finding categorically before the trial court as well as before the.
Page 7, paragraph 71.
Yes, paragraph 71, and in the trial court judgment, your lordship will find at page 48.
So, Mr. Counsel, what is the fault in the findings arrived at in respect to issue number 4?
Course, my lord, it is admitted that sometimes the plaintiff did not issue any receipts.
Not sometimes. From October 2013 to June 2014,
Not
the
receipt-
plaintiff
not
did
receipt-
not issue any receipt.
No, not receipted.
Then in the month of June 2014, you went to deposit. He did not accept. So on 15/7/2014, you deposited in the court.
Yes.
This fact that you deposited in the court is only a verbal statement made on evidence on affidavit.
That's
But there is no proof of calling the register or files in respect to that miscase.
that one.
These are findings of fact.
And no facts.
Where is the perversity? No perversity. How much time? How much time you want to vacate? No, not time for you to go away today. How much time to vacate?
Six
3
months.
months?
6 months.
6 months. Chal. Laho. Heard Mr. Swenso, the learned counsel appearing on behalf of the petitioner. Mr. D. Chakraborty appears on behalf of the respondent number.
2 and 3, 1 I think has died.
Respondent number 2 and 3. First. The petitioner herein have assailed. Somebody had died, na?
One,
Yes, sir.
respondent number 1 died, your lordship allowed them to.
No, yeah, okay.
Petitioner, my lord, landlady. The tenant
Okay.
died
ठीक
and
है.
her son
The
was.
petitioner herein have assailed the judgment and order, decree dated 12/11/2024, passed in title appeal number 07/2023, whereby the learned court of the civil judge senior division number 2 Kachar Silchar, hereinafter referred to as the learned first appellate court, have upheld the judgment and decree dated 14/6/2023, passed by the learned court of the Munsif number 4 Kachar Silchar, hereinafter referred to as the learned trial court, in title suit number 119/2014. Full stop. Taking into account তার পিছত সেই paragraph 2, 3, 4 আমাৰ judgmentত আছে নহয়, landlord tenantor এইকেইটা ভৰাই দিব আৰু তাৰ পিছত আহিব। In the backdrop of the above legal propositions, comma, this court now finds it relevant to take note of as to take into consideration whether in the facts of the instant case, comma, the exercise of the revisional jurisdiction under section 115 of the code is at all called for. Full stop. It is relevant to take note of. Now, for that purpose, comma, this court finds it relevant to take note of the brief facts which have led to the filing of the instant revision proceedings. Full stop. For the sake of convenience, the parties herein are referred to in the same status as they were before the learned trial court. Full stop. The record reveals that the Respondent number 2 and 3, along with the mother, jointly filed the suit before the court of the Munsif number 1, Kachar as Silshire, which was registered and numbered as title suit number 119/2014. First, the petitioner, the predecessor in interest of the petitioner herein was the defendant in the said suit. First, it is the specific case of the plaintiffs in the said suit that the defendant was a monthly tenant in respect of the shop room, which have been specifically defined, specifically described in the schedule to the plaintiff since 1/6/1990. First, the allegations made therein is that the defendant did not make payment of the rent since October 2013. Full stop. In addition to that, the plaintiffs also mentioned specifically in paragraph number 11 and 12 11 that the said suit premises was required for bona fide use of the plaintiffs. In addition to that, the plaintiff also sought for recovery of the rent for the period from October 2013 till the date of filing of the suit. And further, as well as any other relief or reliefs to which the plaintiffs were entitled to. Next, the defendant filed her written statement wherein various pleas were taken as regards the maintainability of the suit. First, on the aspect pertaining to default in payment of rent from October 2013 till the date of filing of the suit as alleged in the plaint, the defendant averred that the defendant duly made the payment to the plaintiff and the plaintiff accepted the amount but did not issue receipts. However, for the month of June 2014, the plaintiff did not receive the rent, and it is under such circumstances on 15/7/2014, the defendant deposited the rent in the court. On the question of, on the aspect pertaining to bona fide requirement, it was averred that the plaintiff did not have bona fide requirement of the suit premises. The record reveals that the learned trial court framed as many as 6 issues, which being relevant are reproduced here in under page 41 and 42 today. 6. First, the learned trial court, after taking into account, on behalf of the plaintiff, next, on behalf of the plaintiff, 4 witnesses were adduced, and certain documentary, 4 witnesses were examined, and certain documentary evidence was adduced. On behalf of the defendant, she herself adduced as the defendant witness, and further, exhibited various documents. Full stop. The learned trial court, while deciding the issue number 4, came to a categorical finding that the defendant was a defaulter, taking into account that the defendant failed to prove that the defendant paid the amount of rent for the months from October 2013 onwards. And further to that, the learned trial court also came to a categorical finding that there was no evidence, there was no proof in respect to deposit of rent before the court in terms of section 5(4) of the Assam Urban Area Rent Control Act 1972, for short, the Act of 1972. On the aspect pertaining to bona fide requirement, the learned trial court came to a finding that the plaintiff had bona fide requirement of the suit premises. First, on these two issues having been decided in favor of the plaintiffs, the suit was decreed by the judgment and decree dated 14/6/2023. Being aggrieved, the defendant preferred an appeal before the court of the civil preferred an appeal being title appeal number 7/2023. The learned first appellate court decided the issue number upheld the issue number 5, the decision in respect to issue number 4. Which pertained to as to whether the defendant was a defaulter in payment of rent. However, the learned first appellate court interfered with the decision insofar as the issue number 3, which pertained to as to whether the plaintiffs had bona fide requirement of the suit premises. However, taking into account that one of the grounds for eviction as stipulated under section 5 of the Act of 1972 having been proved, the appeal was dismissed, thereby upholding the judgment and decree passed by the learned trial court by the impugned judgment and decree dated 12th of November 2024. It is under such circumstances the present revision proceedings have been initiated. This court have duly heard the learned counsel appearing on behalf of the parties and have also perused the materials on record, including the LCR, which have been duly received. From the materials on record, it will be seen that both the courts below, in respect to issue number 4, had come to a categorical finding that the defendant had failed to prove that the defendant had paid the rent for the period from October 2013 till the date of filing of the suit. These are findings of facts, and the question of interference with those findings of facts can only be permissible in exercise of the revisional jurisdiction, subject to the petitioner herein showing that there is perversity in the findings of facts so arrived at by the learned trial court, as well as the learned first by the court of facts. First, Mr. So-and-so, nothing has been, however, from the materials on record, from the submissions so made by the learned counsel appearing on behalf of the petitioner, and also from the materials on record, nothing would be shown that the findings so arrived at in respect to issue number 4 is perverse. Consequently, it is therefore the opinion of the court, the question of interference with the said findings in respect to the issue number 4 does not arise. Tarvisot, Soima, subject to within 2 weeks, date of the deliver. Aji ki tarikh? What is the date? Today, 22nd? 22nd, na? 22nd. By 8th of August, submit an undertaking before the learned trial court that you are going to vacate within such and such period. Then only, otherwise you proceed with the execution. My normal, both of you know. Hey, kini pa piso kini logai dim. It all these directions. It I think the last Sivani or all these things.
15 man.
What?
Instead of 8.
No, 8 you are giving an undertaking. That on or before 8, you are to submit an undertaking in the manner which will be dictated. You must have seen both of you. Stating, just for example, you are not example, you are to state, yeah, you are going to evict, vacate and hand over the possession to the plaintiff on or before. Aji ki tarikh 22. Do it in the sorry pass.
22nd of January.
On or before 22nd of May, January. On or before 2026, you are to hand over. During this period, you are going to pay certain amount as per what it is. You are to pay that amount. And this would not under circumstances be construed to be a payment of rent. There would not be creation of any landlord-tenant relationship. At this period, you are just a custodian of the plaintiff and you are not going to indulge in any activities by which his rights are affected in respect to that. Apart from that, he would be entitled to the rent throughout the proceedings, for which he will go before the executing court and file it out. They will give you an opportunity. You prove before the executing court that, look here, I have been making payment. These are your undertakings. Exposed.
One of the records will be.
Records returned. Yes, did you find out? এই আগতে কিবা এটা লিখিছিল মোৰ তাত টেবুলৰ ওপৰত দি দিছিল কিবা এটা where is the other fellow আপোনাৰ এই মানুহজন নাম কি বিজয় কলে তাত মোৰ তাত টেবুলৰ ওপৰত এখন কিবা এটা আধা You are appearing today?
Yes, sir.
Okay, tell me what is it?
Presented to the department, section 58 minor of
Scrutiny of claims. The provisions of Rule 30 are regarding to preparation of bills and giving of stamp receipts shall be carefully observed in regard to claims presented as departmental office of the disbursement. What is 33? Preparation. The following instructions with regard to preparation shall be observed, printed. In case of the use of purely all bills shall be filed in and signed in so and so. All correction demand the full account so and so. Oh, and bills are presented on account charges incurred by so and so, sanctioning on so and so. When the payment is desired wholly or partly by the end draft so and so, spaces demand. Dates of payment when possible be noted by the payees in their acknowledgement in sub-vouchers and invoices. So what does it mean? Take it. I have a bigger copy. Where is it? Cash memoranda which do not contain an acknowledgement of the receipt of money from persons named therein are not received within the meaning of so. But a mere writing of the purchaser's name and addresses on a cash memorandum for delivery purpose does not transfer into an acknowledgement to the purchaser that the money has been paid. Cash memorandum will not therefore be regarded as vouchers denoted unless they contain an acknowledgement to receipt of the money from the or in you gave another this one. The it was further mentioned that under the transport subsidy scheme for the period from 1/1/2006 to 15/6/2009, comma, the claims so made by the petitioner were scrutinized as per 44-point checklist by independent and audit agency. And the audit team in its report had pointed out that some of the payments made to the transporters were in cash and hence not admissible. It was stated that it is under such context, comma, the department deducted the amount in respect of such payment made to the transporters in cash and released the balance subsidy in respect of the said claims in view of the fact that the claims did not comply with the provisions of the checklist. You have filed the affidavit in opposition.
Central government. Yes, madam, we have filed a PDP in the.
The record further reveals that the respondent numbers 2, 3, and 4 had also filed the affidavit in opposition. Wherein the stand so taken was that the state level committee is only a recommending authority and not the final authority to decide the issues under the Transport Subsidy Scheme 1971. The decision in that regard of the DPIIT is final. And in the instant case, the DPIIT disallowed those payments made by the petitioner's unit in cash, which is not allowed under the extent policy in vogue. It was further mentioned that a checklist was introduced, checklist to the impugned communication dated 2011-2009 was introduced retrospectively by the respondent number 1 after taking into consideration many aspects of the matter, including various instances of irregularities brought to the notice of the respondent number 1. You have filed also an affidavit? Yeah? Huh? What where is that? You are respondent number 5. Respondent number 5, no? The respondent number 5 had also filed an affidavit in opposition, wherein it was mentioned that the said respondent is only the disbursing authority and acts upon the decisions so made by the DPIIT. First, the stand so taken by the respondent number 5 was that there were certain objections raised in the 12 pre-audit team of the respondent number 1, And some claims were not as per the checklist A for the transport subsidy claim. In addition to that, the respondents number 5 also raised the issue of res judicata in view of the order dated 21/7/2017 passed in WPC number 5742/2011. It is further seen that against these affidavit in oppositions filed by the respondents, no rejoinders were been filed by the petitioner. In the backdrop of the above, the point for consideration before this court is as to whether the petitioner herein is entitled to the amount which the petitioner had paid by cash in respect to the period prior to the point for consideration is as follows, whether the petitioner's claim, whether the deduction of the amount of rupees 2 lakh for number 2, whether the deduction of the amount of rupees 2,46,149 which pertains to payment made by cash by the petitioner to the transporters was rightfully was in accordance with law on the ground whether number 1, whether the communication, whether the respondent authorities, more particularly the respondent number 1, had the authority to retrospectively affect the claims of the petitioner on the basis of the communication dated, impugned communication dated 2011-2009. I think this is the proper. Whether the respondent number 1 could have retrospectively taken away the rights of the petitioner. Taken line to question to whether number 2, if not, whether the petitioner, what relief the petitioner is entitled to. Let me come back. materials on record would show that the government of India had, by the notification dated 23rd of July 1971, had made a scheme for grant of subsidy on transport of raw materials and finished goods to and from selected areas with a view to promoting growth of industries. This transport subsidy scheme which was made in the year 1971, was extended from time to time. In this regard, special mention may be made to the Northeast Industrial and Investment Promotion Policy, bracket NEIIPP, bracket close, 2007, dated 1/4/2007, whereby the transport subsidy scheme was extended beyond 31/3/2007 on the same terms and conditions footstep. It was categorically mentioned in the said Northeast Industrial and Investment Promotion Policy 2007 that an early evaluation of the scheme would be carried out with a view to introducing necessary safeguards to prevent possible leakages and misuses. The relevant portion of the said aspect of the said, the relevant portion of the NEIIPP short NEIPP. Insofar it has reference to the transport subsidy scheme is mentioned here in under, is quoted here in under. Full stop. How are you getting benefit in the year 2006?
2006, Lordship, for other periods except January to March 2006, other periods I have received the entire payment. January, except January to March 2006.
Now you are about this January to March. How are you entitled to this period? Under what scheme?
Under
Transport
7
subsidy is understandable because
71 1971 scheme.
70 how? It is not it is limited to 5 years only. So you were an extended period.
The scheme was extended from time to time. From after 1971, the scheme of 1997 came in, then scheme of 2003 came in, then scheme of 2007.
All these things I understand, but these are not every time it is not being given, nah? For example, here you are entitled from
Like this.
1/1/2006. How? Are you entitled as per the NEIIPP or anything else? Because there has to be a relation with NEIPP.
Lordship, may turn to page 27. Turn to page 27, Lordship. This original 1971 scheme was remain in operation till March 2007.
1996.
This is a notification of 1998.
No, this was made on the basis of the earlier notification. This was extended, why? Now, is a unit entitled to transport subsidy for all times to come? It is for a particular year.
Particular period.
Period. Because here if we say, initially it was for 5 years, then if we see the transport subsidy scheme at page 21, for how long?
Lordship, may kindly see the petition, annexure 2. There is a notification which extended this till 2007.
Huh?
Annexure 2. Lordship.
No, that I understand, but how is he entitled to? Is he entitled because he is under the NEIIPP?
This thing, this transport subsidy also.
It was extended.
Yes.
That is okay. But what about the earlier period?
No, 10 years. So from 1997 till 2007, then NEIB 1997 was there. So under the 1997 scheme, the transport subsidy was also included.
That I understand. You see, one is of 1997. One is of 2007. Okay. Now, is a unit entitled to transport subsidy throughout the life?
Throughout the life of this NEIB for 10 years.
No.
And because 2007 is for 5 years and 1997 was for 10 years. For 10 years, the transport subsidy was given for that particular period. But unfortunately, that 97 scheme is not there for.
No. First of all, he has to be eligible. All industries, they don't get it. If they have carried out, either they have set up or have gone for expansion, modernization, and diversification. These are the things. Now, if he had got the benefit under the NEIP 1997, he get it for another 10 years. 10 years, just for example, at the fag end of the 97 policy, he sets it up, he gets it for 10 years, or he goes for expansion, modernization. So is it on the basis of 97 or on the basis of 2007 he is entitled to?
97. Because my production started before 2007. And
Obviously, it appears because your claim is for 2006.
Yes.
What have you mentioned out there? Let us see.
Seeing your Lordship's question, so Lordship may come to page 21 for the time being, paragraph 3. The initial period of claim under 1971 was for the period of 5 years.
Okay, 2004. 2000 gave his year and produce of the 90% is allowed to register under one. So you set up in the year 2004. 2004 you set up on the basis of the NEIP 97.
Yes.
Because that was holding the field for 10 years. Didn't it? So this was given for 7 years initially. And this was extended by this notification.
Till 1971 was for 5 years.
No, 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 no. no. Initially, when that office memorandum came in, on 24/12/1997, this transport subsidy scheme would be extended further insofar as any states are concerned for a further period of another 7 years. That is up to 31st of March 2007, being coterminous with the 10th 5-year plan on the same terms and conditions as applicable now. Now, this happened here. Then again in January 1998, they made an amendment whereby it was extended to 31st of March. Right? I think this appears to be. And thereby inserted net fee as the nodal agency. It seems to be that the transfer for the purpose of getting benefits from to and fro from the raw materials. It is relevant to take note of it is relevant to take note of that the government of India in the Ministry of Industry, Department of Industrial Policy and Promotion had issued an office memorandum dated 24/12/1997, whereby the Transport Subsidy Scheme 1971 was extended insofar as the northeastern states were concerned for another period of 7 years, that is up to 31st of March 2007. First, 7. On the same terms and conditions as applicable. First. This was followed by another notification issued by the Ministry of Industries, Department of Industrial Policy and Promotion, dated 29/1/1998, whereby the transport subsidy scheme was further extended till 31/3/2007 for the northeastern states. The record further reveals that the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, issued an office memorandum dated 1/4/2007, whereby fiscal incentives and other concessions for the northeastern region was announced effective from 1/4/2007. First, relevant herein to mention that amongst the various incentives included the incentive pertaining to transport subsidy scheme, which was earlier validated or applicable, operational till 31/7/2007, 31/3/2007. First, the relevant portion of the said office memorandum dated 1st of April 2007 being pertinent insofar as transport subsidy scheme being pertinent is reproduced here in under page 30 tase Roman 14 yellow corridors. It is relevant, it is further pertinent from a perusal of the above. It would be seen that though by the office memorandum dated 1st of April 2007, the transport subsidy scheme was to continue beyond 31/3/2007. But it was categorically mentioned that an early evaluation of the scheme would be carried out with a view to introducing necessary safeguards to prevent possible leakage and misuses. This aspect of the matter is very relevant for the purpose of the adjudication of the present proceedings. Inasmuch as on 2011-2009, the impugned communication was issued, wherein a checklist of 44 points insofar as transportation of raw materials and finished goods prior to 10/9/1909 were to be examined or pre-audited, which is checklist A, and checklist B of 49 points for scrutiny of claims arising for transportation of raw materials and finished products on or after 10/9/2009. The present proceedings pertain to the period prior to 10/9/2009. And therefore, in terms with the checklist A for the transport subsidy scheme, while making the scrutiny while examining pre-auditing, the authority concerned has to take note of the details as provided in checklist A, which included, amongst others, the bank statement for payment made to transporters during the period, payment only by a check. Taking into account the office memorandum dated 1st of April 2007, and reading insofar as the transport subsidy scheme is concerned, and reading the same with the impugned communication dated 2011-2009, it is the opinion of this court, that the same checklists so required were in relation to the safeguards which have been mentioned in the transport subsidy scheme in the office memorandum dated 1/4/2007 insofar as the transport subsidy scheme is concerned. Therefore, this checklist is nothing but a clarification as to how the transport subsidy scheme was to be operationalized, and the benefit thereof is to be given to the industries units who are entitled to claim transport subsidy. The case of the petitioner, as would be as submitted by Dr. A. Todi, is that by operation of this checklist, certain cash payments which have been made by the petitioner prior to the checklist being introduced have been rejected insofar as cash payments made to the transporters. And this was not envisaged as per the transport subsidy scheme. It is the opinion of this court, comma, that these checklists, that as this checklist relates back to the office memorandum dated 1/4/2007, comma, and these being safeguards introduced so that bogus payments and manipulations are not carried out, comma. The question of and these being introduced in order to check doubtful obliques unscrupulous claims, comma. In the opinion of this court, the question of interference does not arise to the impugned communications. First, it is relevant to take note of that the petitioner herein, having been enrolled and having been eligible to be entitled to the transport subsidy, would be entitled in the manner as provided under law and cash payment, leading to doubtful oblique unscrupulous claims having been disallowed, comma, in the opinion of this court, comma, the question of interference with the impugned communication dated 2011-2009 do not arise. First, consequently, comma, this court therefore is of the opinion that the first point for consideration and consequently this court opines in respect to the first point of consideration that the respondent number one was justified in bringing into bringing in the communication dated 2011-2009 insofar as providing checks and balances in respect to disbursement of the transport subsidy claims. First, accordingly, the instant writ petition, first, in that view of the matter, comma, the second point for consideration does not arise. First, number 3. Accordingly, the instant writ petition stands disposed of as hereinunder, comma. And accordingly, this court do not find any merit in the instant writ petition for which the stands disposed of. Dismissed.
It's a contempt proceeding, my lord.
Invite, huh?
If you order continuing, my lord, said,
What is this?
my lord, the order was passed by this honorable court until yet it has not been complied with, and the action containing, my lord, page 107, my lord. Middle part. If upon verification. So, verification the police committee will everything.
I've received some instruction, my lord. My lord, first, my lord, the second page may be filled in compliance, my lord. In compliance, my lord, this committee was constituted, my lord. And the second last page may be seen, my lord. The report of that committee, second last page, my lord. I'm reading, my lord, from bottom, my lord. From 6th line, my lord. From 8th line, my lord. Starting with, as per information received from local people during inspection, my lord, breach of the embankment was occurred during 2018, immediately after execution of the construction of due erosion by the Brahmaputra. In this regard, public notice was issued to know detail of the scheme and grievances, if any, and accordingly, public hearing was taken in the office of the circle officer.
What is this case, Mr. Samaria?
These are the, my lord,
You have undertaken some work
the-
and you wanted the money.
yes, but the work has been done by us, my lord, and afterward, my lord.
Why so many people have done the
My
work?
lord, because, my lord, there is a, my lord, scheme under the village that those who are local people, they will only get the work, my lord. The individually, my lord, their little work has been given 5 lakh, 6 lakh, my
So
lord.
there is no work order.
So work order, because the imminent emergency arose for, my lord, imminent emergency arose for the purpose of filling up that, my lord, erosion part, my lord.
So I'm asking you whether there were work orders.
No,
or
work
not.
order was not issued, my lord.
So then who knows who has done any
That's
work?
why the inquiry was held, my lord, because there is a direction given that after verification, if found okay, my lord, then payment has to be.
You
My lord,
give-
that
you-
after as per direction, my lord, we have created this committee, my lord. And committee found, my lord, that there is no, nothing is there, my lord. Because
was
as per
washed
the
away.
yes, that is why now we
But,
are
my lord,
having
work
very
has been
trouble.
done, my lord, reports, as per my learned friend says, the execution has been done, my lord. As per my learned friend says, my lord, the 5th line, 6th line, that execution has been done, but afterward, because of the Brahmaputra
that
erosion, that has been washed out.
People's.
It happened and before the people could notice it properly, it was washed away.
And
But anyway, my lord,
First of all, how is your writ petition at all maintainable?
my lord,
You file a lengthy affidavit.
I'll file my.
6
And in the
weeks.
meantime, in the Zoom, my lord, this present respondent has transferred my. I'll file affidavit, yes.
You file an affidavit after 6 weeks. These are orders which cannot be complied with
Yes.
due respect.
That is why we are facing
It's a
problem.
big problem. How do you do it?
Yes, my lord.
Go file civil suits. When there is no embankment there, how will these people at all go into and look into and no work orders? Anybody can claim.
My lord.
Okay, Mr. S. Doctor, the learned counsel submits that he required that he has received some instructions whereby it has been duly informed that a report have been submitted and the said report is now going to be placed before the chief executive officer of the
Correspondent.
Morigaon Jila Parishad. And the said report would be finalized after the report of after the analysis and comments of the chief executive officer. Full stop. He therefore submits the 6 weeks time may be granted in that regard. Full stop. The instructions which have been submitted is placed on record and made and is kept on record and marked with the letter X. Full stop. Lists the matter on 15th of September 2025. In the meantime, the respondents shall file their affidavit.
So this is regarding that matter where that retrenchment took place and we had taken up a ground that the continuous service was not there. And Lordship on the last occasion had asked me to take instructions regarding the reinstatement, whether it's possible or not. At 240 days continuous service.
Oh, yes, the depot, Tinsukia depot.
Tinsukia Depot, which has been ultimately closed. And then lawsuit had posed the question as to whether his reinstatement is possible. I took my instructions. Factory is no longer there. They only have an office in Calcutta where they do some trading now. So otherwise, the production unit and all these things have closed long back in 2005. So the issue is, and another aspect is regarding the age of the workmen, that they also do not have any instructions as to what record, because our entire case was, he was a casual employee who had worked intermittently, and therefore there were no records. Because he claims by way of a 1994 appointment letter issued by the then branch manager, wherein an appointment was given. Though we raised the dispute regarding that particular
That
appointment.
you are making it here, not in a written statement.
Written statement, we had said that
No.
1994 appointment letter was issued on a Sunday, and therefore there is dispute or there is doubt. I admit that that cannot be a ground to dispute and nullify an entire document.
And more particularly, you have not given evidence.
Yes, and another aspect is no evidence. Okay,
So,
I will not.
That document remains.
That
The
document remains.
further documents which are given out there, whereby your company has entrusted him to look into many aspects,
Yes.
is also there on record.
On
So that is there. But now the question of reinstatement does not arise.
that is the issue. Okay, another aspect that I would like to place with lawsuit is this is ultimately a case of retrenchment. Now, retrenchment, what is the condition precedent is 25F, which says that there has to be a notice. So the default on my part is that notice. Now, the Supreme Court has dealt in a few matters where this kind of default has taken place, and Supreme Court have taken a view that in all cases, probably reinstatement with full back wages can be an option, but need not be the only option. There can be other options also. And it is also incumbent upon the other side, the workman, to show that he was not gainfully employed at the period of time to claim the 100% back wages. Therefore, on merits of what has been found by the labor code, probably I'll not be able to distinguish that, very frankly speaking. But on the aspect of the relief granted by the labor code, if I may just place very small 2 or 3 judgments on that aspect, just to
What is the relief granted?
that you'll also find in the last page 35.
Reinstatement with full back wages. 35.
Page 35. Ground taken by us was that he was disqualified. There was no termination letter. His services were discontinued without there being a termination letter from 1/1/2000 because of financial hardships. So that being a case of retrenchment, my only default would be that.
And there is no departmental proceedings.
It is a case that's squarely covered under retrenchment 200, because there is no departmental proceeding, there is no stigma, there is no nothing of that regard. In fact, there is no termination letter. It's a simple case where the person comes and complains before the authorities, the labor authorities, that I have not been able to join, they have not allowed me to join. So it's a case of discontinuance of service. So therefore, it's a retrenchment. And the ground taken was financial hardship that ultimately led to the closure of the factory itself. No employee is working, no workman is working thereafter.
And when did you stop your depot?
2005. And this is the incident of 2000. So that financial hardship has started is ultimately culminated into a closure of the factory. So in a case of.
How do I know that the work is finished after, so you have closed in 2005?
That notice that you'll also find in the repetition itself at page 15. The matter went before the BIFR, and finally on 27/6/2005, this closure has taken place of the factory.
So what happens when you close down your industry then?
If there is a closure that amounts to retrenchment of all the employees, and thereafter whatever dues are there, it has to be paid to them.
How did you pay?
Regarding this employee, the conditions is before your lordships. It was just, he was discontinued.
No, you see, the problem is of the award is of 2013.
Yes.
Okay. you did not place this aspect most probably before them, before the learned labor court. So therefore,
court, we
if
have
I am
taken
to
the ground
take
of
note of, he may be entitled to full back wages till 2005. So how do you analyze that? He will be entitled to full back wages till 2005 because if you have closed down in 2005.
In
Now
fact,
what
I've got-
happens? I mean, there has to be a golden handshake.
The observation by the learned tribunal was at the point is that, if I just read out one line, instant case, there is no evidence on record showing that Workman was the man who joined the company last. There's also no evidence on record showing that other than the Workman, any person was retrenched for financial hardship. So therefore, my
But
retrench,
this happened in 2010, 2000,
2000,
2000.
2000. At that point of time may not be.
I
But
understand.
the
what Lordship
fact
is trying
in
to say is that,
2005,
sir, until closure, full back wages.
full back wages.
Thereafter, at par or parity with how others were dealt with.
That is what I'm
That's
asking.
what.
This is how the things has to be resolved somehow.
Those instructions or those records are not available. They do not have also closed their office at Assam. The office that they have, the address that I have given.
The question is, you have to do one thing then. The best way out is to bring on record somewhere. By this affidavit, you say that you are only closing it, but whether if you are closing it, a notice would not affect. When a particular unit is closed, you need certain, it's a factory.
Factory.
So you need factories, the certain official
Certification.
confirmation as regards closing down.
Certificate.
So that will be there. So you have to bring on record that document by which I can come to a finding, because your letter doesn't, you cannot say. Officer and special duty, he's saying out there now. There must have been a reconstruction if your company is still functioning, because a unit does not go to sick BFI. It's the company.
goes- Company.
So if the company has become then revived, the company has to be revived. Most probably there must have been a scheme.
They have an office in operating. in-
There has to be a scheme, because when it was declared to be sick, at that point of time, as per the Sick Act, so he was declared to be sick. So there must have been reviving, because as of now you are appearing.
And
So
there was
therefore,
no liquidation took place.
Therefore, you have to show me something, some document that what happened there in that the BFI proceedings, how it got closed. That there must have been said that the Tinsukia unit will be closed down. Whether it has been closed or how it is being taken note of, the BFI proceedings will categorically show. Or
Sometimes
did
some
it?
units are closed and some units are kept revived.
Huh?
As has sometimes some units are closed and some units are kept revived.
No,
As it
revive,
happens-
this is subject to some scheme.
Yes.
There has to be a scheme. So in that scheme, it will be mentioned that Tinsukia depot should be closed.
In fact, a judgment will be there. BFR judgment will be.
So
Yes.
bring something on record to the effect. Then only I can fix it.
I understand.
And the BFI judgment will also say how those persons will be taken care of. Then only I can help you out. He will also get something. In the meantime, is
No, I
there?
was totally lost contact. The phone number which I had, I called up, it landed up in North Lakhimpur. I think I write a letter and post it up. I was waiting for this day. Whatever happens, I'll write it up. And send that kindly contact.
Maybe he
phone.
is employed somewhere, gainfully employed somewhere. He was a
That's
casual
a
labor at that
speculation.
point of time.
That's a speculation. Of course, he might have
No,
survived.
that's speculation. You see, I have to
understood.
exercise the certiorari. Certiorari, I can only exercise, I'm telling you to the limit. That okay, question of reinstatement, if you have closed down, does not arrive. But there has to be some payment to that effect.
That
So
I also agree, Lordship. Some
So,
payment has to
so
be made.
therefore you have to come up with those documents that it has closed down. What has happened in the BIFR?
In fact, I brought a judgment which says payment till closure. So now therefore I need to ascertain the date of closure and what was the effect of pursuant
And
to
the closure will be given in the BIFR.
BFI order. Yes.
BIFR will be approving a scheme
Correct. Correct.
like we have in the Insolvency Act. There is a scheme,
resolution
the
plan.
scheme is being approved under this credit resolution, all this CDR and all. It is being approved. But BFI also had the same scheme. Although what was happening is all these industries, more particularly these tea industries who were in default, they went there and asked them to declare as sick. The moment there is a sick, then in view of section 22 of the SICA Act, no proceedings, no claim, all DRT proceedings stalled. And this has resulted in why, because of that, the BFI became a useless thing. So find out this thing, how it is to work.
It will give me some appropriate time.
Okay, we have it on 12th of August.
Hardened part, my, hardened part,
Hardened part.
Huh?
hardened part.
It's already hardened part.
I presume.
So the call.
You must have.
Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the Tinsukia depot wherein the petitioner was, the workman was working and since been closed. And the petitioner company no longer carries out any work in a manner, carries out any work of similar nature when the workman was working. At present, the petitioner company is only engaged in
Trading activities.
trading activities. And as such, the question of reinstatement of the petitioner cannot be permitted, cannot be visualized. The learned counsel further submits that pursuant to a BIFR proceedings, the Tinsukia depot was closed. Full stop. Taking into account the said submission, this court inquired with Mr. A. Sharma, the learned counsel, as to whether there is any record, official records to show that the Tinsukia depot was closed. Full stop. Mr. Sharma submits that he would obtain necessary instructions in that regard and place it before this court by way of an affidavit. This is the matter on 19th of August 2025. Any affidavit the petitioner wishes to file, the same be filed on or before 13th of August 2025.
Applies enough.
May please. Looking at this requisition, we are challenging the preliminary award of the labor code on the validity of the disciplinary inquiry as well as the final award. Because in
Preliminary award. Why you are
Preliminary-
challenging here?
so we had challenged it, then to send back, then again a final award was passed. So we, in this petition, we are challenging both the preliminary award.
No,
on
you
the
don't challenge the preliminary award. You challenge the final award. Okay,
Final,
preliminary.
we have challenged, Your Lordship.
Preliminary award is mostly on the question of fairness of the disciplinary inquiry.
Validity, because we had filed an application that will rely on the evidence and on the disciplinary inquiry. So accordingly, a preliminary issue was framed, whether it was valid or not, evidence was led, and then the labor court finally came to a conclusion that it was not valid. On grounds which, if I may submit, is not tenable, on the grounds of violation of natural justice. Then we came before this court then came to a finding, since the reference is not complete, at this stage, it is not necessary for the court to intervene. So it is sent back. If necessary, we can have a chance to challenge both after the reference is complete. So reference went against us. So we are before your lordship on both the issues. So if your lordship will sign, if see the preliminary award, there were 4 grounds. One was that he was not given a presenting officer. The second was that he was not explained that he is entitled to defense.
Entitled to?
defense. Third, your notice of inquiry was sent by the management.
Why are you making a presiding officer, labor court a party?
Lordship, that may be then strike off, that is not necessary.
Has the Supreme Court not deprecated the practice of
Yes.
doing it?
Yes.
Anyways, then
Third was that the inquiry, a notice of inquiry was sent by the management instead of the inquiry officer himself. And the fourth. And the proceeding was completed in 1 day. So these are the 4 grounds, which I may show from the record as well as I will submit from the judgments that these findings are erroneous. If the preliminary awards goes, then I will rely on the findings and evidence of the disciplinary. One is that, because after that, the evidence, those transfers given to the management after the conclusion of the preliminary award, that we can lead evidence, because we had taken the lead that if it goes, if the preliminary award is not enough, then we should be given the opportunity to adduce evidence at the first instance itself. Though we are given an opportunity, however,
why the other side is not represented?
what I have been told, senior advocate Das Gupta, he has been representing all throughout, but I think he is informed that the file has been taken from him.
Is a stay?
Yes.
No stay.
The first.
Oh, so stayed. But there is no 17B.
That is pending.
Hello, you pay the 17B first. And you have to pay the 17B first from the date on which you have filed the requisition.
In that regard, I know that 17B I cannot escape unless I have to show that he is into some meaningful employment.
And if it is pending, means he has filed an affidavit.
Then I have to bring proof, which I have not done. Only one judgment, Lordship, from date, your Lordship is expressing that from the date of filing the writ petition. Only one judgment for your Lordship consideration, from the date of filing his affidavit. That's one judgment. Otherwise, I am bound to pay. Supreme Court today. Respected days after. Supreme today, but I have the Supreme Court citation, 2005 11 SCC 449.
No, this was direction is for a particular reason. Because till that time, there is no affidavit filed. So there was a direction that you file your affidavit, then you will get the amount. This cannot be taken as a ratio for that.
Here also they have filed the affidavit much later.
Irrespective. So pay that first. After paying, then we can hear. Okay, preliminary inquiry, that aspect goes. Now, what is your main on the, yeah?
Lordship, what has happened as I was submitting, though we are given opportunity to adduce evidence after the preliminary inquiry, but most of the employees who had given evidence in the disciplinary inquiry has either retired or left.
I'm not on the preliminary inquiry goes.
That's why
It has been properly done. Now, come to the merits.
then what happened? Because then
Now,
we
come to
given
the
application-
merit. No, mister.
Yes, that's what we had. given
Kindly come
application-
to the merits
Yes,
now.
merit is, your lordship, that we had given application that will rely on the evidence given in the preliminary evidence, which the labor code.
With that, you cannot.
Labor code has,
That is no evidence. Labor court evidence is different from a preliminary inquiry. That person concerned doesn't have the authority to take evidence. Does he have the, as per the Evidence Act?
adduced for labor. Code. The preliminary issue that was framed was framed by the labor code.
So the evidence was adduced where?
Labor code, the opportunity of cross-examination was given to the.
Okay, then
So that the preliminary finding was observed by the labor code that it is in violation of the, which in my humble submission, if I can submit to law.
don't submit. Then
But after that, though opportunity was given to us to give evidence, but we could not give evidence because.
did you say that you want to adduce evidence?
Yes, at the initial stage itself, at the final.
No. When you filed your written statement,
Yes, we have given.
did you say that let us first adduce evidence for preliminary inquiry? Because preliminary inquiry is not preceded by evidence unless you want to say something. Hey, file to the auction records.
Initially, Your Honor, we had filed a WS. In the WS, we had taken the plea specifically that we want to rely on the disciplinary finding. And that's why there should be a preliminary issue on that. If it goes against us, opportunities will be given to us to deduce evidence. Your Lordship, in terms of the.
Ah. Preliminary inquiry award was passed on 33/2015.
Yes,
Thereafter,
we came before this court.
no, it's okay. Thereafter,
We gave an application that will rely on the evidence.
wait. 14/12/2016. Seen petition bearing 6/16 filed by the management side praying for adjournment on the ground that the learned counsel is out of station. Heard, prayer is allowed. 6/27/2016 for evidence of management side on merits.
Yes. Then we had given an application there stating that most of the employees had retired. And that's why we should be given liberty to rely on the evidence given.
And that was allowed on 17/5/2016.
Yes.
Then
So then we relied on, and we had exhibited a document where there is an admission of guilt by the workman. Because the M1 who had given evidence in the preliminary issue is not a direct eyewitness. He was a manager. So he had given evidence only to show that the disciplinary inquiry has been conducted properly in due compliance of natural justice. Accordingly, all the documents were exhibited to show that it was only other document on merit was the document where the admission of guilt was there. But that was not considered by the labor court.
what?
The admission of guilt by the workman. That was exhibit 13 of the.
Not considered that document is another aspect
Yeah,
from not giving you a permission to give it.
I stand corrected, not
Don't
considered document.
come up with, you are saying something which is absolutely wrong. You have to come directly to the point out here. What is your case? Your case out here is, first you come up and say, then look here, I was not permitted to adduce evidence after the preliminary inquiry, although I've asked for, this is wrong. No, wait. Then you say that we have already adduced the evidence in the preliminary inquiry and the court allowed this to be tendered. That evidence is being allowed to be tendered. Now you are saying that particular document exhibit 13 have not been taken into consideration.
Stated we have not been allowed. My statement was we have made an application since the employees have retired. We should be given opportunity to rely on the evidence given in the preliminary inquiry.
That was permitted.
Permitted. So now the evidence that has been adduced by the management mostly pertains to the validity of the disciplinary inquiry. He was not a direct eyewitness. Only thing on merit that I can rely on is a document that he has exhibited is the admission of guilt by the workman, which was not given due consideration, and accordingly on merit, the labor court has dismissed.
So therefore you are on the appreciation of evidence, but
if the preliminary finding goes,
I'm not going to go do that.
if your lordship kindly turn to page
No, that is absolutely right.
134.
No, not
Lordship,
134. No 134. So
134.
your question is on appreciation.
No, your lordship
Okay.
is also on the law that how the finding that it.
I am on 226.
Yes, lordship.
Shashri.
124, your lordship. You can-
No, file is
The order
closed
of this order.
now. I think we should dictate.
134, your lordship.
What 34? What for what?
130, order of this code.
Huh?
Page 134.
Ah.
The order of this code after we came challenging the preliminary award. At this stage, the decision in copper engineering may once again be averted to. In the said decision, the apex court made it abundantly clear that there would be no justification for any party to stall the final adjudication of the dispute by the labor court by questioning its decision with regards to the preliminary issue when the matter, if worthy, can be agitated even after the final award. The apex court further clarified that it would be also legitimate for the High Court to refuse to intervene at this stage. At this stage is the preliminary issue. Your lordship, last paragraph. In the light of the above, particularly the clarification of the apex court in copper engineering, this court is not inclined to invoke its writ jurisdiction under 226 of the Constitution of India at this.
I can quote that only by removing at this stage.
And if your lordship sees, he was given ample opportunity. And there was compliance of natural justice. He was given notice of inquiry stating what are his rights during the procedure. He was given opportunity to cross-examine. He was given opportunity to submit his list of witnesses.
One day.
Not one day. That notice of inquiry is sent prior. And though
Everything is in 1 day.
in 1 day, but the
How
order
many witnesses were there?
6 and 1, 7. He has adduced one evidence, one witness.
Understood. 7 witnesses all in 1 day.
But the finding was after a month, after due consideration.
Huh?
Finding was not given on the same day. Finding was given after.
Finding is different. It is the question of violation. You see, a departmental inquiry is not is set aside or said to be good, not good only on the ground of principle of natural justice, nothing more than that. If I remember, there is one judgment. What is that? What is that? Book. something, 1965 or something. What is the judgment? 1965 or something. Lutbuk Singh or something. Lutbut Singh, yes. So there also it has been said that the preliminary inquiry normally should be kept out there. But if it is only in violation to the principles of natural justice, then now what is the fair thing? You have 6 witnesses to be examined, cross-examined. How will the workman do? And you have not been allowed the defense assistant?
No, that is a wrong conclusion because we have given that I will show by the notice of inquiry. If your lordship sees a notice of inquiry has stated everything. That he is allowed to take his defense. That's why he produces list of witness also. He cross-examined also. He himself has cross-examined.
How will you know? Well, workman was doing what?
He was also a laborer in the garden, but he was a
Laborer.
laborer means he was a employee of the tea garden.
What was he?
Yes.
Working as? You don't know that.
Patient water.
Where is the inquiry report? Final inquiry report is where?
Final is
Sorry,
page 139. Starts at 148. You're the worker. The allegations are otherwise quite serious. He had incited the other workers not to work.
Oh, the court have also taken note of exhibit 13,
That in,
page 155. No,
yes,
no case.
if your lordship says, I just want to rely few judgments on the.
Indranagari has failed to prove the area committed misconduct and thereby management has justified Iman with 50% only. After causing so much of trouble, he has given only 50% black wages. No, this is a fit case for making it 100%. As regards the domestic fairness of the domestic one, with there were only two witnesses. Where is exhibit 13? Ah. Where is it?
130
Page?
136. This is after the conclusion of the domestic.
Where?
137 and 158.
Where is his signature?
Next page, the original one.
Which one?
138.
Read it. Read it. Let us see what it says. This was in 2004.
This was after the conclusion of the domestic inquiry.
Huh?
After the conclusion of the domestic.
Domestic inquiry was happened when?
Domestic inquiry, conclusion was the report. Page 38. 22/3/2004.
And did you put a question to him during his cross-examination on this document? Before the labor court?
He, during my cross-examination of our witness.
No, not yours. He. Workman had deduced evidence. Workman had deduced evidence. Did you question him on this document? He reduced the evidence of two witnesses.
That's we. That is M1, M2 are our witnesses. That's a management.
Are you sure? Kindly come to page 148. Necessary.
Yes.
In spite of having sufficient opportunity to adduce evidence on merit, management did not adduce evidence, so and so, so and so. Thereafter, MW1 was cross-examined by Workman. Thereafter, Workman's side also adduced evidence of two witnesses, and they were cross-examined by the management side. What? Are you saying that is perverse? This is not how you prepare, Mr. Counsel. A sorry state of affairs. cross of MW1, it is not a fact that Hiren Bhumis confessed his guilt by letter dated by the exhibit 13, last line of MW1.
The cross examination of MW.
Last but one line, which was taken on 26/8/2016. Then
21/6/2014.
26/8/2016. Very poor set of state affairs.
The document shows here 21/6.
I'm not concerned with your documents, I'm concerned with the records. Then you by yourself say that it is not a fact that so and so confessed to his guilt. Then how can you say so? This is signed by your, what is this? Dinesh Nayak. This is by, no, WW. WW son of Dinesh Nayak is who? Huh?
MW1, George John Mbopan.
This is by Dinesh Nayak.
That is a union.
He has denied it. So this was is not confessed. Then Dilip Kumar Bora. Who is Dilip Kumar Bora?
Bora is the managing group who has conducted the inquiry. Is the advocate. Is MW2.
You were only concerned with the water tank being stopped, na?
Stop the workers from working, saying you should stop work. Since they were not obeying, he is from a different union. So he stopped the water tank. So they were not able to complete the pesticide spray. That is one incident. The charge sheet was given that during that pendency, he again incited the workers. There was two second charge. He again incited the workers saying not to accept the wages because they are deducting the union subscription fee. And on the next day, again incited the workers to create righteous behavior.
But the second allegation which is there have not been proved in the domestic inquiry.
Second charge.
Ah.
Yes.
Yeah. In the cross of this one, WW2, he says, means WW2 is that Workman. Allegation laws against me are false. Exhibit signature in exhibit 3, 4, and 13 are not my signatures. I submitted reply against the charge sheet. It is not a fact that I committed misconduct on so and so as alleged by the management. It is not a fact that management is dismissed illegally. Class 4, a person who is from class 4, you are asking him to cross-examine. On step after praying, I admitted my guilt on so and so. I did water tank. He is denying. You have put a question, he has denied it.
My entire case hinges on the finding of the preliminary, that preliminary award, which is bad enough.
If that is
Yeah,
valid,
yeah.
then I can rely on proceedings of the disciplinary.
Huh?
Because otherwise, post the preliminary award, my only case is on exhibit 13. That is,
That is gone.
so that was, that is why I want to impress upon your lordship regarding the finding of the preliminary award is that.
So if your preliminary inquiry goes, then nothing remains.
If it's the preliminary, then I can rely on the disciplinary report.
And the CBI inquiry, no case. CBI inquiry is on 13th. Who has exhibited exhibit 13?
MW, management witness 1. That is, your lordship will find that page 87.
Now, he has not identified that it is his signature. Isn't it? Then, okay.
That is why initial my case, your lordship.
On
I-
preliminary inquiry.
Preliminary.
So let us go on the preliminary.
Page 121, relevant part is 124.
What is the ground? Let us see. They written a long judgment. The following are the infirmities found. No presenting officer was appointed by the magistrate. Enquiry officer did not explain to the workman that he is entitled to take defense assistance.
Regarding the
He
first point,
great, up till class 4. How will he know? You ask him to cross-examine 6 witnesses in one day. Not possible. Was issued by the management which ought to have been issued by the enquiry officer. Within one day, the enquiry was started and completed on the same day.
regarding the first.
And for you, and you take this matter to be decided so many years. 2010. He was dismissed from 2004. We are 21 years. Yes, Mr. KP Pathak, you come here and help me out. How we dismiss the petitioner's case with cost. This is a case for cost. We can make it how I can exercise and make it 50 to 100% as bank wages. And secondly, because on merits he has no case. He is banking everything on preliminary. There are only 4 grounds on which the preliminary inquiry was held to be bad. 1, no presenting officer was appointed by the management. 2, the enquiry officer did not explain to the workman that he is entitled to a defense assistant. Notice of inquiry was issued by the management which ought to have been issued by the inquiry officer. Within one day, the inquiry was started and completed. Okay. You find out only one thing and tell me how we can convert this 50% of wages to 100% back wages. Dismiss to dismiss only. How can I exercise 226 and make it 50 to 100%?
Before that, regarding this 4 ground, which you judgment on that, and also I would like to bring to your attention the notice of inquiry.
Huh?
The notice of inquiry at page 35.
Page 35. Huh? Oh, I have a meeting. You escaped today. Hello. Matter having been heard at length, list the matter again Thursday at 2 p.m. We finish it up at 2 p.m. No, not necessary. I'm just at 2 p.m. we'll dismiss on that.